Hello. Memo rafle. All memos are allowed.
My lord,
Yes, sir.
my lord, your lordship may kindly recollect. This case, my lord had dealt with that in spite of order by this honorable court, the
Stay is there.
Stay is there.
So give it for orders.
Can it be day after tomorrow? my lord?
No. Please just allow him to distribute. This week there is some difficulty.
Next week?
I mean, order se kebe jaldi as paribo.
Next week, hello, sir. Your lordship may recollect that stamp collector is ordered by another coordinate bench. He refused and directed you pay. Your lordship quashed that order. Again, he passed that order in spite of lordship, sir. When they bent upon not to hear.
Fresh matter.
Fresh matter, man.
Very fresh orders. Fresh.
Except Friday, any day, if your lordship.
Yes, yes.
Friday, my lord. Today is Tuesday. Thursday will also be.
Next week on.
Yes, sir. No.
Friday, there is a possibility of this bench not functioning.
Yes, my lord. That's why I said.
Tomorrow there is a.
My lords will be sitting in different break benches.
Yes.
My lord. Friday is break bench day.
Pressing necessities are also there.
My lord, that's why I said not Friday. Any day suiting to a lordship's convenience board.
Any resolution on 27?
My lord, I was just requesting the honorable secretary.
Asked me
I was just requesting the secretary to have that.
One reason is that the new. I mean, it's a new body.
New government, man.
Not that far. And they will prove their worth.
Well, I was just requesting the secretary.
Second part is actually there's some relevance. More important is that you will pass a resolution that no adverse order will be passed. So the resultantly, it is better to have a working day than to have a day where no adverse order will be passed due to difficulty. Usual.
In fact, also my lords are accommodating us. If we are held up in another courts, my lords are accommodating.
That is there, but that is without resolution. But whenever there is a resolution, I mean, both sides, obviously, they are not pressing that since for the so and so function are available that way. Anyway.
Grateful.
Page 2, 3 to 14.
Memo dei दियंतु पण जेते समय नबा सेते हमकु से समयटा किछ अपचय होची मु तो मेमो अलाउ कर दोछ ना मु एक्चुअली मु कैलकुलेट करूनी
एटा टिके सार को सहित कथा हली एटा डी नंबर रे अछि आई एटा नोमेनक्लेचर
क्लास नै आसो कना से आपण से जो
नोमेनक्लेचर
सबले मेंशन करिवे योर जॉब इज दैट आपण जो पुरानाटा विथड्रॉ हे गला कोन दैट फॉर हाई कोर्ट जोडा आफ्टर द न्यू स्टैंडिंग ऑर्डर डिफेक्टिव कांसेप्ट पळेला सो सेटा लेखिकी ताको फाइल करिवे सो दैट से बुझी परिवे regarding law I have already had a discussion, lengthy discussion with everyone, registry and SR and everyone I have discussed. I'll say should rahibani gradually it will be taken care of. So twice matters, there is a batch of matters defective law, so that was listed. The orders ko aribe defective one orders without defect of fresh.
My lord, item 6 may kindly be adjourned.
Page 2, 3 to 14.
If 6, you are Mr. Patra, Mr. S. Patra.
I am on behalf of Mr. Patra.
Your name, sir?
Nirmal Behra.
Mr. Nirmala Behera.
May be considered taken after the vacation.
Let us. The matter being in the list is mentioned on behalf of the learned counsel for the petitioner for adjournment. Start. But after vacation, accordingly, the matter shall be listed
Who comes in
for fresh admission in the week commencing
छह सात
6/7/2024 ଆପଣ 6/7 ଯେତିକି ଦେଖୁଛନ୍ତି ମତେ ଲାଗୁଛି ଅଧିକ ଆଡଜର୍ନମେଣ୍ଟ ହେଇଛି
तथापि
ଆପଣ ଟ୍ରାକ୍ ରଖୁଛନ୍ତି
କରୁଛି।
yes
Lordship, item 10, Lordship.
10
Pray for an adjournment, Lordship.
Mr.
On behalf of S.
Malik.
Mahapatra. P.K.
S.
Malik, Lordship. My name is P.K. Malik.
sorry
On behalf of S. Mahapatra,
PK
Lordship.
Malik
P.K. Malik, Lordship.
PK Malik on behalf of S Mahapatra item 10 for the petitioner opposite party blank the matter being in the list same order କରିପାରିବେ ତ ରିପିଟ୍ କେବେ ଚାହୁଁଛନ୍ତି
2 weeks after, Lordship.
which the vacation ହେଇଗଲା now there is a problem sir the last
After
2 weeks
vacation,
of vacation
Lordship, after
they have fixed 11/5/18 they have crossed 150
Lordship, after vacation, Lordship.
so likelihood of reaching the matter is important ଦେଖନ୍ତୁ ଯଦି ଆପଣ ବିଫୋର ଭେରିଫିକେସନ ଯୋଉଟା ଫ୍ରେଶ ଆଡମିସନ ରଖିପାରିବେ ରଖନ୍ତୁ ବହୁତ କିଛି କହିବାର ଫ୍ରେଶ ଆଡମିସନ ଅଛି ତ
Obliged.
Page 3, 15 to 22.
Item 20, Miller. The matter is infectious. And there is a settlement between the parties and
what is Mr. Samar yes
the family court.
so you have shifted your place so I thought that you have left
So writ application
so
is,
kindly file the
Withdrawal
whatever
memo.
memo you are filing both of you please sign
I have already signed.
ତାଙ୍କୁ କପି ଦେଲେ ବୋଲି ଆଟଲିଷ୍ଟ ସେତିକି ତ ହବ ସାଇନ୍ କରିଦିଅନ୍ତୁ
These are,
ଠିକ ଅଛି ଠିକ ଅଛି କୋଡ଼ିଏଟା ତ ଅର୍ଡର ୱିଲ୍ ବି ପାସ୍
these are.
ସିପିଟା ବି କୋଉଠି
Hey,
ସିପିଟା ତ ମୁଁ ଫାଇଲ କରିଛି ନା ମୋର ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ ସେଟା
withdrawn already.
ଅଲରେଡି
ହଁ।
କେଆରପି ନା ମୋର ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ ତ ମୁଁ
That already withdrawn. 15/4
ପନ୍ଦର ଚାରି
ଆଜ୍ଞା
କୋଉଟା 251ଟା
CP 262/24 ବାରିପଦାରେ
ହଁ
ଏଟା already withdrawn on 15/4.
ଅର୍ଡର ଅଛି କି
ନାଇଁ 15 ତାରିଖ ଦିନ withdrawn.
ସେଇଟା ମେନସନ
ମୁଁ
କରି
ଲେଖିଦେଇଛି ସାର୍ particular.
ତାହେଲେ ଠିକ should have short copy then so that Mr.
ମୁଁ
Samar
ଦେଇଦେଇଛି ସାର୍ memo ରେ.
ଗୋଟେ ଜେରକ୍ସ କରିକି ଦେଇଦେବୁ
ଜେରକ୍ସ
yes page 3 15 to 22
Your Lordship, item number 21.
21 yes
Your Lordship requesting to adjourn this matter after vacation.
anyone from Mr. Jenna
Yes, my lord. I have no objection.
ଆପଣଙ୍କର you are Mr. Mahanti
SK Mohanty.
SK
SK Mohanty.
Mahanti yes SK Mahanti Miss P.E. Das 21 lecture P.E. Das for the petitioner opposite party Mr. SK Mahanti the matter being in the list the matter being listed for orders is mentioned by the learned counsel for the seeking adjournment the matter shall be listed in the week commencing dates going to 6/7/2024 yes
Page 4, 23 to 28.
My lord, 25 and 26.
yes
Same order may pass after launch, after vacation, ma'am.
after notice state 25-26 adjournment ଚାହୁଁଛନ୍ତି ମିଷ୍ଟର ମିଶ୍ର ପୋଷ୍ଟିଂ କରିଦେବେ 25-26 କେବେ ରଖିବେ
We commencing 6/7.
we commencing 6/7
Interim order,
ଉଚ୍ଚ ମର୍ଡର ଅଛି କଣ
sir. My lord.
ତାହେଲେ ଆପେନାସ ଦେଖିବାକୁ ପଡିବ 26 ଲେଖନ୍ତୁ
ଦେଖିକି
Mr.
କରିବେ।
Sushant Kumar Mishra for the petitioner Mr. Prabhu Prasanna Behera for the additional standing counsel for the opposite party Learned, the matter is listed for hearing under the heading for admission Learned counsel for the petitioner 6 and has adjournment for addressing arguments list in the week commencing list the matter shall be listed for admission in the week commencing 6/7/2024 interim order passed earlier shall continue till the next date of hearing 26 भी से
Yes, yes.
26 मिस्टर प्रभु प्रसन्न में
Oh, sir, both are sir.
yes
Item 24, my lord.
24 yes
Paper adjournment and state yet not filed counter.
24 for interim order ଅଛି
No.
তাহলে 24 simply post date कर देगा
6/7
week commencing 6/7
Counter to
24 Mr. Lekka
Yes.
Mr. Behra
Name. Prabhu, Prabhu.
Prabhu ठीक है
public.
yes
page 5 29 to 37
33 35 में
33 मतलब
35
35 Mr. Behra
On behalf
you have
of-
power here
विक्के नायक on behalf of विक्के नायक नेक्स्ट वीक में
Mr. Pujari senior को inform करंतु
हम पाएंगे
see asi फिर he usually comes
Aye.
so it's after notice matter will come around 3 p.m. you must understand you should have 35 date करते हैं तो
will commencing 6/7
नेक्स्ट
commencing
वीक
6/7 yes
33
next week
Next.
after notice matter काय अर्जन करछन तो पढु
नहीं,
I don't know whether पढिबो कि
नहीं,
नहीं मैं कहि परिबिनी किंतु
सफरिंग फॉर फीवर माइंड
सेमती केमती हो सफरिंग फ्रॉम फीवर ले कोन तार कोन अछि रिलेवेंस अछि नेक्स्ट वीक तो आज के ले 7 दिन रे भलो होछि कि भाई ला भलो भी हो आफ्टर बिफोर वेकेशन चाहुछन्ती आपण बिफोर वेकेशन को सेटा
18/5
है वी कमेंसिंग 18/5
हाँ, fine.
but you must understand that it has crossed 150 11 18 week
33 my lords.
33 yes
My lords, this matter has already been settled, and my lords, because of preparing the draft, my lords, may I pray that this matter may be taken up on 27th so that this matter can be disposed of on the same day.
27th रखंतुनी because adjournment issue हो बोले I was checking with Mr. Bose
My lords,
like yesterday all the matters have to be adjusted or not
my lords.
that comes as
This matter will,
on 3 से रखंतु for orders
my lords,
or to be
for-
mentioned
to be mentioned, my lords, both the parties can also file their joint affidavit.
नहीं आपण appearance ले detail रखले better हो
Detail of it.
ठीक अछि आपण 33 टा देखिबे कोन छटा केते तारिख कहले 29 मार्च at 2 p.m. 29 ना 30 देखो
Thanks, your lordships. Vote is convenient, my lords.
जापुला बिजी ना अभी मां में भी अवेलेबल सिटिंग है
30 तारीख था
30 Margaret 2 p.m. he is more busy than you
yes sir
so Mr. Mahapatra is more busy than you
yes
you have to ask him yes
30 तारीख साथ
30 तारीख 2 p.m. Margaret 2 if they are appearing no difficulty
They will appear, and my lords, they will file their joint affidavit.
there is a difficulty in preparation of duty
My lord.
that is
what if
will file also joint
but
affidavit
only issue is that that heat to ask them they will be reaching at 2 the heat
They will
wave
come by-
condition
They will come before, my lords,
Before
because
that-
they will have to file their joint affidavit.
so a liberty to mention 33 lekhantu Mr. D Mahapatra Devidatta Mahapatra for the petitioner Mr. Sheikh Jafrul party 33 the Lord Council for the parties jointly mentioned the matter being in the list stop it is submitted that in a very welcome development the parties have arrived at an amicable settlement acceptable to both stop they submitted that the matter may be listed for orders so that it can be taken up and disposed of. Stuff. Para. The matter shall be listed on 30 4/2026 for orders marked at 2 p.m.
Okay.
Think, orders are conduct shall be listed on 2 p.m. to lekha habo. Anyhow to be at 2 p.m. Yes.
It's interim order to continue. Then.
Interim order as passed earlier shall continue in the next date of hearing.
I'm grateful.
पण आगुरी भी लिखले होते हैं मैटर भी टेकन अप कौन लिखते हैं मैटर भी लिस्टेड फॉर मेंशन इज मेड सिर्फ लिस्टेड फॉर उस लाइन तक कटते मैटर में भी टेकन अप यस
Grateful.
यस
Number item number 39, next page.
नेक्स्ट
page 6 42
39, my lords, just now I have received the copy of the counter filed by the opposite party. So I
तो प्रधान
My lord, I'm appearing. Yes, Hota. My lord, I filed the
okay 39 you suggested date agree for a date since it's after notice matter both of you are required to be present so agree for a date it be after vacation or before vacation
before vacation. Your lordship, there is a stay in this case, your lordship.
the stay to hobo
Lords,
or else what the court will adjudicate.
My lord, I have filed an vacation of
If the
stay.
coordinate bench has thought to grant a stay, I am not going to vacate
I
that.
have filed an vacation of stay, your lordship.
let it be taken up after vacation, but so I have to take instruction. My client is staying at Milord's Hyderabad.
That's
Lords.
My lord, the issue is
The next date ତାକୁ ରାଜି କରିବେ ନା ଆଜି ରାଜି କରିବେ?
I just
That's I have to file the
Conda
reply.
has got. ଆଜି ଆପଣ ରାଜି ହେବେ ନା next date ରେ ରାଜି ହେବେ ସେଟା vacation ପୂର୍ବରୁ ଆସିବ ଆଉ ଗୋଟେ date.
vacation ପୂର୍ବରୁ, your lordship.
ହଉ ଠିକ ଅଛି।
18
We commencing 18/5.
Obliged, lordship.
Yes. Please simply post it above further orders. Yes.
Interim
Interim order is not touched. The adjournment na stay order.
stay order.
Stay order ଅଛି. Not touched. Yes.
Lords,
Item 1.
let it be continue till at least. No? Lords.
Mention लिखिए order लिखिए। Mr. Anam Charan 39 लिखନ୍ତୁ Mr. Anam Charan Panda for the petitioner. Your name, sir?
S hota.
Mr. Susappa Dota for the opposite party. The method being listed for admission is mentioned by the learned counsel for the parties. Stop. It is submitted by the learned counsel for the petitioner that he has received a copy of the counter in court today.
Well,
Stop. The matter shall be listed in the week commencing 18/5 received copy of the counter. Stop. See, तापर लिखिए 86 accommodation to obtain instruction from the petitioner. Yes, next.
Item 1.
Interim order to continue. Lords.
Interim order has passed, bears shall continue in the next date of hearing.
Rejection of the application filed by the petitioner under section 30, under section 36 of the special method. Lordship, that is under annexure 7.
Yeah.
Now notice was issued, nobody has
Just
appealed.
look at the paperless. ଦେଖନ୍ତୁ ଅଛି instruction present status ଅଛି last flag B ରେ ଅଛି dismiss ହେଇଗଲା
Should.
can you just go through ଏଇଟା ଆପଣଙ୍କ ପାଇଁ ଅଛି sir ଆପଣ this is future
ଆଜ୍ଞା।
now you have to represent the entire community of lawyers so you have to go read that. ସେ bookmark କୁ ଯିବେ bookmark touch କରିବେ ତାପରେ scroll down କରିବେ status report flag B
ଆଜ୍ଞା।
ଏପଟେ ସାର୍ ଦେଖନ୍ତୁ ଆପଣ ଚଷମା କୁଆଡେ ଗଲା କି
ଚଷମାଟା ଛାଡ଼ିଦେଲି।
ଆପଣ ଦେଖିବାକୁ ଆପଣ ପୁରା ଏକଦମ ସ୍କ୍ୱିଣ୍ଟିଂ ଅଲମୋଷ୍ଟ ଟୁ ଜିରୋ ଆପଣ ଯେତେବେଳେ ପଢୁଛନ୍ତି ଆପଣ ଆଖି ପୁରା ବନ୍ଦ ହେଇଯାଉଛି
ମୁଁ ପୁରା ସେ ତରତରରେ ଆସିଲି ଯେ ଗୋଟେ
ଝିଅ ପଢିଦିଅନ୍ତୁ ଆପଣ ପଢିଦିଅନ୍ତୁ
ମୁଁ ଗୋଟେ ପଢିପାରୁଛି।
last subsequently on 7/4/2023 due to non-prosecution of the petition the CP case was dismissed for default.
ଏଇଟା ତ ନୁହେଁ।
CP ରେ ଆପଣ ଅପୋଜିଟ ପାର୍ଟି ନା
ସିପିରେ ଆମେ ଅପୋଜିଟ ପାର୍ଟି।
ଜିତି ସାରିଲେଣି ଆପଣ ସେଇଥିପାଇଁ ସେ ଆଉ ଦେଖା କରୁନାହାନ୍ତି ଆପଣଙ୍କୁ ପିଟିସନର ହେଇଥିଲେ ଦେଖା କରିଥାନ୍ତି
ସେମାନେ ପସିବଲ ହେଇପାରେ ସେମାନେ ଏକାଠି ରହିଯିବେଣି ଯଦି
ଆଜ୍ଞା ଆଜ୍ଞା
ସେମାନେ ଏକାଠି ବି ରହିଯାଇ ପାରିଥାନ୍ତେ କାରଣ ତାଙ୍କ ଡେସ୍ପୋର୍ଟ ଯାତ୍ରା
that is expected
ଆଜ୍ଞା
that should happen actually.
ଆଜ୍ଞା।
Mr. H.N. Mahapatra for the petitioner other kanti ଏଥିରେ ବିସିରେ ନା କିରା 42 hybrid mode the matter is listed under the heading for referral to the special mediation right 2.0 mediation for the nation pura reiterate karo to order dated 31/3/2026. I'll dispose of Take your seat. I'll just take your floor. Order 31-3-2026, order number 10. Para 1, 2, 3. Pursuant to the order dated 31-3-2026, the registry has intimated the lauded counsel who is present. Stop. Pursuant to the pursuant to the order dated 31-3-2026, registry has obtained instruction from the learned judge family court regarding the present status of CP number 15 of 2017, which is kept in the records marked as flag B. This upon the registry has obtained. Marked as flag B. Flag B. The letter of the learned district judge providing the instruction is dated 8-4-2026. The said letter discloses, quote, subsequently.
That might be the family judge Puri, because the case was posted pending before family judge Puri. Lordship dictated district judge, I'm sorry.
Then it's a correction. So it's a देखी लिखी है. बहुत repairing दरकार होची. Repairing समय भी लागुची. तेणु सेटा किछि करि होबन. अरे dictation है तो कोन लिखे. Discloses that, quote, subsequently on dated 7/4/23 due to non-prosecution of the petitioner, the CP case number 15 of 2017 was dismissed for default. Like we will take in view of the above, nothing survived for adjudication in the present application. Stop. The application is the repetition is disposed of. Yes, next.
Item 2.
Item 2, my lord has passed an order on 23rd to frame a policy by the railway for settling this.
So can you please say the date again?
23 2000.
Last order.
20th March 2000.
Sorry, but 23
Yes,
but I think last week the Honorable the Chief Justice of India has addressed that.
Okay, I see.
Please talk to
this board level. Then
I think they have the Honorable the Chief Justice has already discussed these things with the Union of India, but exact but definite information.
So official
because without policy, same to Mr. Lenka and Mr. Mahanti also, they don't have a policy.
Actually, what happening in not this case, I'm talking about before 2 years. One employee of the railway in Baleswar Postal, they have a recovery of 56 or 1,000 or something. I suggest, why you fighting the case here by paying spending money? Why not above the conciliation process, you can settle the same. The superintendent didn't agree. Then, what is your problem? He told me, until there is no policy, we cannot act it out.
You see, the problem is that they are attributed motive.
Yes. So I give an opinion. Till then, they are not doing this.
They do not have interest actually, but they are attributed for so and so reason, most likely, without any basis, of course. Attribution is a problem. What can be done? So that is how.
Let's give some more time.
So, in fact, I have been telling that in your letter, please write to the government, or in this case, Railways or Union of India, Ministry of Railways, that this is listed for referral to special mediation type 2.0 mediation for the nation.
Yes.
Now they are saying Samadhan, that drive is turned as a Samadhan something. Mediation,
settlement, Samadhan.
So now this is the, 2.0 is now leading to that. So we have to take up it at the state level. Yes, the High Court has to take it up at the chief secretary and the finance secretary, the stakeholders.
Lordship, remember the tax matter, the income tax central excise matter. Also, they have taken a policy this much about.
I was giving that example to Mr. Lenka and Mr. Mohanty that in case of a small amount of land acquisition, it is better because that exercise was done. And Honorable Justice Vijay Mohanty was there, so there was a lot of effort. But again, it reaches a point where they don't have a clear instruction what to do.
But if Lordship today maybe observe about this basing on that observation, Lordship report the law ministry can also take. Now the law ministry is taking up the issue with the cabinet secretary because now they have last 20 there is a meeting of all. So the chief secretary, cabinet secretary assured to the
that I was suggesting. You are saying the same thing.
yes.
Because if you mark this list to enter the High Court on the ring road, one of the case mentioned is a land acquisition.
Yes.
But land acquisition, state is the acquirer in most of the cases. So then what should there should be a policy? Otherwise, the state government or the lawyer also cannot obtain instructions.
Exactly.
Mr. K. Padi, senior advocate, SGI, along with Mr. Samantray, senior panel counsel. Mr. S.K. Samantray, CGC. Mr. M.K. Ponda, for the appellant respondent.
Others are other cases, other councils are there and pass on the slip mail. Yes.
I was sub item.
They put a कागज लिखी दे. Put a slip देले लिखी दे.
Okay.
तो better that
Slip to the
learned ESGI referring to the order code 20.03.2026 submits that he requires further time to obtain instruction, particularly with response to paragraph 4, which is reproduced herein. It is submitted that as per his instructions, there is some development and it may so happen by the next date. It may so happen and the matter may be adjourned. Maybe adjourned. According to the matter, after vacation.
After vacation.
The matter shall be listed in the week commencing 6-7. So Ponda, you are in all matters.
No. 3 matters are there.
अच्छा ताले ठीक आपन को ना बेटी लिखि देबे अपेलेंट को पई की रेस्पोंडेंट को पई की गोटे कागज रे लिखि दियो आपन जोटे लिखन जेटा सर को देले सी लिखि देबे की लिखि देबे आपन
One Birendra Kaur party name is there earlier he was CGC then name may be deleted.
अच्छा ठीक अछि प्रथम आइटम रे जोठी वीरेंद्र पाड़ी सीजीसी अछंती हमरा को देखि लिखि देबे name of Mr. Virendra Padi, learned CGC, who was appearing earlier. Virendra Padi, learned counsel, who was appearing earlier as CGC, shall be deleted from the case brief as well as the cause list, in as much as he is no more empaneled. এইটা আপনারা রেজিস্ট্রি ফাইল করিও
Registry yes.
Can it can be taken up before vacation? So that
before vacation को लाएगा 18 I have told you that say that already 250 list eichi. So we have to adjust so many things like yesterday's matter has to be adjusted. ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ଆସିବ କଣ ଅଛି ଟଚ୍ କରିବାଟା ଇମ୍ପୋର୍ଟାଣ୍ଟ
How after vacation?
ସାର୍ ନ ଚାହିଁଲା ମୁଁ ଚାହିଁଲା
ତେଣୁ ସେଇଟା ପାଇଁ give some there is some positive development. Hopefully there will be a policy. Mr. Padi, even you have to talk to them.
Yes.
They can have a system of stringent scrutiny. Because policy has also a problem.
So what happening?
This has happened in Odisha.
Actually,
this has happened in Odisha.
What happening?
Suktel project. This has happened.
What?
That's strict scrutiny if they can. So at least each case will be scrutinized by your authority.
Yes.
Whoever is getting through, let him at least get rid of the litigation. Whoever is not getting then you can continue the litigation. Of course, as far as apportionment is concerned, the state has no say, the parties have a say. But they are also not agreeing for apportionment, especially married daughter's family,
Yes.
as you have found in Western Odisha, almost all places. So they are not, there is a lot of
Compulsion is there also.
mega power project, there is a lot of litigation where daughters are claiming and is stuck in litigation in High Court.
Now is value of the compensation will increase. That's why
It has.
even though as a person is not interested, by showing the value, they are coming and
Mega power project amount is substantial.
This is a old case. Now 100% solution. By senior is agree, it can be.
So that I was telling. So in some cases, they have to consider the advice of the counsel that if in the it's an old case now, if it is taken up in the present, much more.
Yes.
Then solution was not there. All these things.
Yes.
Those are the niceties they have to understand. And kind of a checklist they can have. ଛଅ ସାତ ରଖ ଯୋଉଥିରେ ବୀରେନ୍ଦ୍ର ଆପଣ ମାନଙ୍କ ନାଁ ଦେଇଦେବେ ଟିକେ yes next please Mr. Jena.
Yes. This is RPF.
Item 3A.
Yes. 3,000 for wife and 2,000 for children.
Yeah.
Technically 5,000 only. But the question is, एटी अलगा रकम केस कोन मते से काढी देई कि मो घरे से रहउचंती.
Sir, please appreciate this. I am thinking myself to be a talking judge, especially 125 and 24 is concerned.
नहीं मो आगे ता
आपण सुनिलेन तो फिर नाही आगे
माइनर
मु जज नुह बोली कोन कहिबि
ना.
बाहरे कहबे ना एठी कहले केनते हो I wish to contact. So you have to have develop the habit of listening and understanding. ଆପଣଙ୍କ ଘରୁ ଯୋଉ ବାହାରେ କରି ଦେଇଛନ୍ତି now the what provision.
Yeah.
So now you have the time, you address me, no problem. But after you complete, I will ask you very pertinent questions on facts and law. Correct? Then what happens after 1.5 hours, after you submit? In one case it happened. Then you have no answer. The entire 1.5 hours and I take 10 minutes,
Yes.
1 hour 40 minutes is wasted. So my humble request is that please make a submission which is not bereft of records. So now in your pleadings in written statement,
yes,
where you have stated,
yes, madam.
show your written statement.
Madam, ta cross exam.
My lord, no, written statement. In your written statement, where on oath you have stated that you have been driven out of your house
Yes.
by wife and children.
Cross exam. I am clarifying.
Written statement, sir. Cross examination ही परियोनी बिना written statement रे. It's a matter of fact.
Written statement था मु जोड़ी नहीं आ गया खाली evidence टा.
आपण देखी भी ना.
Written statement.
Whenever a client is coming to your chamber and giving you a speech, you should ask him this question.
Yeah.
Otherwise, it becomes impossible for you and completely impossible for the court to take up also.
Madam.
You must understand. And
Yes.
revision is very limited, much less than an appeal.
ए केस रे मु खाली वन टाइम सेटलमेंट करिया पे चाहू छी.
One time settlement maintenance नाही.
नहीं
provision रे अछि.
से लोक गोटे एग्जीक्यूशन केस
Sir, कॉपी रे तो one time settlement को provision रे अछि.
माने
एटा
एटा
बैंक नु आइ. अपन
से-
बैंक केस करी एथरे ओटीएस भर्ती
ना से
करले.
माटा
मेंटेनेंस रे नाही कोठी. कोन जदी कोठी स्टैट्यूटरी प्रोविजन अछि, जजमेंट अछि, वन टाइम सेटलमेंट जोटा सेटा आपनकर लोन रे हुई.
एटा कंसिलेशन गले मु कर
कॉन्सिलेशन रे हे परिबो.
कंसिलेशन.
Conciliation appealment रे conciliation नाही. आपण देबे की? You will pay, Mr. Jena will pay or I will not pay. I am sure. I cannot pay also. Don't have capacity to pay. Whenever a client comes to you and says, when he told you that they have been driven me out of house,
Yes.
you should have asked your client kindly show the written statement.
जोड़ी नहीं कि रिटन स्टेटमेंट रो अछि.
Dollar डाले आप.
एविडेंस रे भी अछि.
Sorry, entire 5 minutes is wasted.
से आसु एपियर करू एट लीस्ट.
No, no. Dismiss. ताको एटी मोटी इनविटेशन
माने एटा शॉर्ट डेट दिथाम तासु.
जा प्रोसीडिंग हला
मु
रेकॉर्ड
आगे-
रहबो आपण एडजमेंट काहे कि नेबे आपण बुझिबे.
हां.
I cannot waste time.
नहीं नहीं मु एडजमेंट नो छै.
नहीं जा डिस्कशन आगे लिखा हो बसंतु शुणंतु.
हां.
Mr. Gopal Prasad Jena for the petitioner. And our approach should be serious and studious. We need to at least to this to a certain extent. It's a legal conversation, legally nuanced conversation. ଆପଣ secure କରିବେ amount ଟା? Will you secure the amount by depositing before this court?
Maybe
Execution file ହେଇଛି.
execution file.
So no stay will be granted and this order will be communicated to the executing court. This is not a fishing expedition. ଆଜି ପକେଇଲେ କୋଉଦିନ ମାଛ ଧରିବ ସେ ହବନି.
Subject to deposit.
Not subject. Affidavit ଦେବେ, deposit କରିବେ, ନେବେ. ଆପଣଙ୍କ fishing expedition ରେ court କୁ ପାର୍ଟି କରନ୍ତୁନି. If does not want to pay, let him face the consequence. The civil court decree, এটা 125 ନା 24 ନା କୋଉଥିରେ? 125. 125(3) ଅଛି. It's not to be bargained before the High Court.
ନାଇଁ ମୁଁ ଏଠି ବାର୍ଗେନିଂ କରୁନି, ମୁଁ କହୁଛି ସେଠି ଟଙ୍କା ଦେବି କିନ୍ତୁ ମୁଁ ତାକୁ ୱାନ୍ ଟାଇମ୍ ସେଟଲମେଣ୍ଟ କରିକି ସେ
One time ନାହିଁ ଆଜ୍ଞା. ଆପଣ ଗୋଟେ don't make the High Court order a laughing stock.
ନାଇଁ ସେଠି ଗୋଟେ ସେ ମାଟା କରିଛି ମୋ ଏଗେନଷ୍ଟ, ସେଇ ମାଟାରେ ମୁଁ କରିଦେଇ ପାରିବି।
Whatever, ସେମିତି କରିହବନି. 125 ରେ ମାଟାଟାରେ ହେଇପାରିବନି. ମାଟାରେ 24 ରେ ହେଇପାରିବ. ସବୁ ଜିନିଷ ଡିସ୍କସନ କଲେ we will spend another half an hour, nothing.
ନାଇଁ
Only the petitioner husband in the marriage is before this court, challenging the judgment dated 23.08.2025 by the Lauded Family Court, Noyagad, in CRL.M.P. number 121 of 2023. The said CRL MP, signed by the wife in the marriage and the minor daughter, is it about 8 years? Is it then about 8 years? Under section 125 of CRPC, claiming monthly maintenance of rupees 18,000 per month. The marriage was solemnized between the parties on 8/2/2013.
yes.
Stop. The IE was favored. The petition was favored by the Learned Judge Family Court. However, directing grant of maintenance at the rate of rupees 2,000 for the child and rupees 3,000 for the mother wife, the total coming to rupees 5,000 from the date of application from 09.06.2023.
962.
090 to say that. In deciding the matter, the Learned Court has examined. The Learned Court has considered the statement of 3 witnesses on behalf of the wife petitioner, the evidence, the written statement, as well as evidence of the opposite party husband. Stop. It has considered as many as 3 exhibits on behalf of the petitioner's mother and child, and about no and about dash page 14 dash exhibits marked on behalf of the opposite party. It is to challenge the order. It is submitted by the Learned Counsel for the petitioner to challenge the order in revision before the court. It is submitted by the Learned Counsel for the petitioner that the opposite party husband has been driven out of his house. In response to the said submission, it was submitted. It was brought to the notice of the Learned Counsel that, in view of the judgment of the Honorable Apex Court regarding scope of revision in Samima Faruqi versus so and so, the present petitioner has to show from his pleadings and evidence rendered before the learned trial court that such plea was taken. Stop. Now, the learned counsel for the petitioner does not have copy of the written statement nor the depositions. He seeks adjournment. Stop. It is further submitted by the learned counsel for the petitioner that the matter should be settled in one-time settlement into bracket OTS. In considered view of this court, the concept of one-time settlement is not applicable, rather unheard of in case of proceedings under 125. Samima Faruqi Sahidkar लिख लेनी 2015 into bracket 5 SCC 705. The matter shall be listed for fresh admission in the week commencing as prayed for. The matter shall be listed for fresh admission in the week commencing
8-5 ପୂର୍ବରୁ ହବନି
8 ରେ ଅଛି execution. ଏ order ତ ଆଜି ପଳେଇବ executing court.
ଯାଉ ମୁଁ ଏଠି ପିଟିସନ ଟେ ଦେବ
ନା ନା এটা adjournment ସେ କରିପାରିବେନି
ନା ପଇସା ଦେଇକି କରିବି
ଆପଣ ଟିକେ କେତେ ସମୟ ଲାଗିବ ଗୋଟେ କେସ୍ ରେ without doing anything we are just spending time. 8-5 ଦଉଛନ୍ତି in the week commencing 4-5. In view of the judgment of the Honorable Apex Court in Rasnis versus Neha, the amount granted as maintenance is akin to a money decree. The learned counsel for the petitioner shall obtain instructions as to how the petitioner will secure the amount or will deposit the amount before the learned executing court for sustaining challenge to the order. One day, Mr. Jena, I will be happy if I can pass a different order to interfere in these kind of orders, because you see, it has become very repetitive. As I was predicted, the entire time will be wasted. Upon OTS, I would have called a
ମତେ କାଢି ଦେଇଛନ୍ତି କହିଲେ ଆଉ ପ୍ଲସ୍
ସେ ଯୋଉ ଜିନିଷଟା is not relevant. We are being washed, Mr. Jena, we are being washed. Suppose I pass a order, people will be thinking that law students of law, that what this court is doing. ଆପଣ ଚେକ୍ ବି କଲେନି ପ୍ଲିଡିଂସ୍
ନା ତାଙ୍କ ଏଭିଡେନ୍ସ ଅଛି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଅଛି
କାଇଁ ଦଉଥିଲେ irrelevant statement କାଇଁ ଦେବେ
ନାଇଁ
when you make irrelevant statements before court
ମାର ଇରେଲେଭେଣ୍ଟ ନୁହେଁ ସବୁଆଡେ
ନା ଦେଖି ନାହାନ୍ତି ଆଜ୍ଞା
ମୁଁ ରିଟନ୍
ଷ୍ଟେଟମେଣ୍ଟ ତ ପଢି ହିଁ ନାହାନ୍ତି ପଢିଥିଲେ ଆପଣ ସାଙ୍ଗେ ସାଙ୍ଗେ କହିଥାନ୍ତେ
କିନ୍ତୁ ଏଇଟା ଅଛି ଏଭିଡେନ୍ସ
ଦେଖିବେ ୟୁଟ୍ୟୁବରେ ଆପଣ କଣ କହୁଥିଲେ ଯେତେବେଳେ ପଚାରିଲେ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଦେଖାନ୍ତୁ ଆପଣ କଣ କହୁଥିଲେ ଜଷ୍ଟ ୱାଚ୍ ୟୁର ସେଲ୍ଫ ଇନ୍ ୟୁଟ୍ୟୁବ ସେ କଣ କରନ୍ତି
ରଡ୍ ମେସନ ହାତ ଭାଙ୍ଗି ଯାଇଛି
କଣ କରନ୍ତି ଆଜ୍ଞା
ରଡ୍ କାମ ମିସ୍ତ୍ରୀ
ହାତ ଭାଙ୍ଗନ୍ତି
ରଡ୍ ମେସନ ହାତ ଭାଙ୍ଗି
ମୁଁ କହିଲେ ହାତ ଭାଙ୍ଗନ୍ତି ସେଇଟା ଗୋଟେ ନୂଆ ପ୍ରଫେସନ
ରଡ୍ ମେସନ
ଠିକ ଅଛି ସାର୍ ହେଇପାରିବନି ଏ ଜଷ୍ଟ ୱେଷ୍ଟେଜ ଅଫ ଟାଇମ ଠିକ ଅଛି
Item 4.
Sir, you have to being officer of the court and you have to raise yourself. କହିବ ରଡ୍ ମେସନ ହାତ ଭାଙ୍ଗି ଯାଇଛି ସେଟା ଆପଣ କଣ ଦେଇଥିଲେ କୋଉଠି ଦେଖିବେ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଏକ୍ସରେ ହେଇଥିଲା କି ନାହିଁ ତାପରେ ସେ ତାର କଣ କାମ କରୁଛନ୍ତି
କିଛି ନାହିଁ
ଜମି ବାଡି କେତେ ଅଛି ପଚାରିବେ
ଜମି ନାହିଁ
ତ ନାହିଁ ଆଉ
ଜମି ନାହିଁ
ନାହିଁ ତାହେଲେ ତ ଭଲ ସେ ତ ଷ୍ଟେଟ ଗେଷ୍ଟ ମିଷ୍ଟର ଲେଙ୍କାଙ୍କର ଗେଷ୍ଟ ହେବେ ଆଜିକାଲି ମିଷ୍ଟର ଲେଙ୍କାଙ୍କ ଗେଷ୍ଟ ହଉଛନ୍ତି ସବୁ ଇଟ୍ ହାଜ୍ ହ୍ୟାପେଣ୍ଡ ଆପଣ ଭାବୁଥିବେ nothing is a joke, it is a serious matter.
My lord.
Joke is found that part where you are not making any substance the tension ଆପଣ ତ କିଛି କହୁନାହାନ୍ତି ଇଆଡୁ ସବୁ ଚାଲିଛି ଡିସ୍କସନ ସୋ ସେଇଟା ବି କରିବା ପାଇଁ
I make pardon,
ଆପଣ ଆପିୟର କରୁଛନ୍ତି ଅପୋଜିଟ୍ ପାର୍ଟି
ନାଇଁ କରୁନି
Usually orders matters are not mentioned.
Mention the sorry already, sir.
My lord, I'm in extremely personal difficulty. My wife is ill seriously. Therefore, I pray.
अरे नहीं आपण के आस्तिले कहीं
item 13 टा withdraw
जणे कहले जे मु पर्सनल डिफिकल्टी कहलारु से मना कले हम कहले नहीं नहीं वाइफ तो देह खराब डाकिले पड़े
मोरी मैटर टा थिला उतर कहथि से
पर्सनल डिफिकल्टी मना कले आपण एसोसिएट
आज्ञा
माने यू आर हैप्पी और यू आर इन ग्रीफ
आई एम इन ग्रीफ
because at times actually जेतले माने
मु आ काको फोन करी पाइलिन
देह खराब कला चुपचाप सोइले कोन ले से द हस्बैंड बिकम्स हैप्पी जा किछि कहू नांती किछि नाही
आइटम 13 टा विड्रॉल करियो गोटे मेमो टे देछि
अदर साइड पड़े बोले
नहीं अदर साइड
ताकू टिके कटेसी देखांतु और दे ही विल बी इन ग्रीफ आपण को ग्रीफ रे खाली कोर्ट को जोडछन्ती
तादरे चलो तो अमिताभ अछि
हां कहि दियो
कहि दउ मु ता कहि देबी धर की
ठीक अछि ठीक है आप यू कैन हैव योर सर यू आर नॉट सपोज यू कुड हैव इन्फॉर्मड एनीवन इन द कोर्ट्स
क्या मिलिले
एटलीस्ट द गवर्नमेंट काउंसिल द दिन सारा रहउछन्ती ता कोइ दे परथांते सेते कोन
दिन ला सिन तो कोर्ट को 11 12 दिन ला
आप जा कहतले से आपण याडे कोर्ट रे न आसले भल लागुनी घरे भल लागुनी लास्ट ऑर्डर कोन हेतला ना फाइल देखि ना देसे फाइल देखु ना एटी देखो देखो मिस्टर जेना योर मैटर इज ओवर मिस्टर दास काइंडली जस्ट हैव योर सीट कोन मिस्टर आचार्य कहउछन देखियो सेठी आचार्य सर उठी फाइल देखन आइटम 13 मिस्टर दास का जस्ट आइटम 13 आरपीएफएम 99
लास्ट ऑर्डर कर था এটা লোক अदालत को जाइतला ता समान को भीतर
ठीक अछि तो 14/5/19
my lord
ये लोक अदालत का
it was referred to continuous लोक अदालत but it could not be settled there that my client knows ha it
माने in fact I am also appearing I think as a judge in look adalat and that's an interesting part anyway it will be withdrawn now okay. Yes पढ़ला बेले कहबे
Item 4, please, your lords. Look, here the petitioner is the husband, lord, and he is seeking transfer of his case filed by his wife under section 144 of BNSS, lord, which is erstwhile 125 CRPC, from the court of Learned Family Court Kendrapada to Learned Family Court Bhubaneswar, lord. Lord, I have filed this application on 2 grounds, lord. Now, under section 145 of BNSS, lord, Lord Sanhita provides under the jurisdiction of which court, my lord, the application under section 144 can be filed, my lord. And
please mark the opening sentence.
Proceedings under section 144
yes
may be taken against any person
before any court
in any district A, where he is, or B, where he, her, or his wife resides, C, where he last resided with his wife, or as the case may be, with the mother of the illegitimate child, or D, where his father or mother resides.
It's not necessary,
my lord.
So then, in view of 145, how do you say that it can be transferred at the instance of father?
So therefore, my lord, at the very first instance, the wife could not have filed the case in Kendrapada.
So that is a plea for lack of jurisdiction before the trial court.
Lord, sir.
You must understand.
My lord.
If you want to win the case in 144, you may take that plea, but how the High Court will decide that? So I am here to allow, in the last 5 years, I am here to allow 126 application for transfer, because the language is wherever she is, she can file. Because the opening statement is any district against anyone in any district.
In any district.
If you compare with section 19 of Hindu Marriage Act.
Yes, Lord.
Or CPC.
Yes, Lord.
So this is completely a different jurisdiction and one itself. It is, and it remains unamended.
Not
126.
Yes, Lord.
And the only thing is that if you want, so then you can appear if it is possible through ICT, that VC and other things, that is possible.
My lord. Lord, I have, in fact, these other ground, which actually the grounds for transfer I have taken, there is a consistent threat on my life, and I have taken.
You inform the judge, presiding judge in 144. I am yet to file a petition where the husband is feeling threat for life, but also in every petition there is a threat to life, no FIR, no intimation to the judge.
Indeed. Absolutely. Correct. This has not happened.
In one case, in case of 138, the threat is to the family member, but still no FIR, not the husband is not intimated. I'm sorry, the judge is not intimated.
Lord,
threat to life cannot be developed because this is not a police station. This is, I have been asking.
Lots.
Suppose somebody comes here and calls that I have a threat to life. What the High Court will do? Because then from which place to which you are seeking transfer?
From Kendrapada to Bhubaneswar.
So now the High Court will direct the threat to life is there, not there at Bhubaneswar, but is at Kendrapada. So that will be ridiculous. You will definitely laughing outside.
No.
So that is the other.
Then, my lord, it can be since the wife has also filed a case before the husband has filed a Section 9 application in the court of Bhubaneswar, and it has now been filed. It has now been challenged and seeking for a transfer to the Kendrapada by the wife, and the case is by this honorable court. So may I Lord, submit that both these cases may be tagged together and cases.
I mean, that is what I was expecting from you. So that was telling Mr. Jenna. This is a lawyer should advise. Because they do not know what they are doing. They start quarreling. Then legal advice is not, should be like that, that should help them.
Not.
So let us list these cases together.
Yes, Lord. Lord, I have one close
But the problem is, suppose, since he feels threatened at Kendrapada and safe at Bhubaneswar.
I'm talking.
So you have to talk to him whether he will be feeling safe for transferring of 9 to. Obviously, I will not make any comment.
Yes,
I will not observe.
Yes, sir.
But if you can ask him. You ask the husband whether transferring of Section 9 to Kendrapada, because I cannot pass an order that Bhubaneswar is safe.
No, no,
if you compare Bhubaneswar with Kendrapada, now Bhubaneswar is Kendrapada is safe. Time has changed.
What?
And for these kind of matters, the Lord's counsel for the petitioner husband in the marriage is before this court. Seeking transfer of criminal proceeding number 95 of 5 pending before the Lorded Judge Kendrapada, the Lorded Judge Family Court Kendrapada to the court at Bhubaneswar. The criminal proceeding CR.P.K like CR.P.95 of 2025 has been initiated by the wife in the marriage and infant son born from the wedlock. Under provisions of Section 144 of BNSS, seeking monthly maintenance. So, the learned counsel for the petitioner refers to Annex 2 of the petition, which is copy of the order dated 20.01.20226 passed by this court. In TRP into bracket C number 1 of 2026. The said TRPC has been filed by the wife in the marriage for transfer of the C.P. number 458, CP number 458 of 2025 from the Court of Learned Judge Family Court Bhubaneswar to the Court of Learned Judge Family Court Kendrapada. The CP number 458 has been filed by the husband in the marriage under Section 9 of Hindu Marriage Act, seeking restitution of conjugal rights. It is submitted by the learned counsel for the petitioner in the present application. Petitioner husband in the present application that the matter, both the matters may be tagged together and listed in the interest of justice and for effective adjudication. Since both the matters are in the determination of this bench, both the matters shall be listed for fresh admission in the week commencing. Above. Okay, so that particular. Why never touch? 27 चल रही हो ना पूरा तो आज नहीं होता है अभी 23 कुछ fresh admission on.
But till that date, if the petitioner moves an adjournment, application for adjournment.
This in view of the above order passed, it is further directed as an interim measure that upon a prayer being made seeking adjournment in the pending CR.P. number 95 of 2025 before the learned judge family court Kendrapada. The same shall be adjourned to a date beyond 11/5/2026 as would be convenient to the learned court in season of the matter.
Item 7.
Mr. J. Barik for the petitioner.
Item 5.
Mr. Das, sorry.
In pursuance to the order of this honorable matter, I have filed the WS internal. The prayer was filed WS in the matter. I have filed. It included to file WS, therefore I approve this honorable. This honorable direct me to file WS with a stipulated time. I have filed. There are which one? We don't know.
Opposite party by sir. Suit ne kaha by sir.
Opposite party.
Opposite party.
Opposite party.
ये पढ़ी में सर और आपका एटीटी के असिस्ट कर ऑर्डर नंबर 1 ऑर्डर नंबर 1 टा देखिए
Order number 1. And the petitioner wife is before this court challenging the order dated 1/11/2025 passed by the land judge to report for good, which agreed. Thus, both the parties are absent. Amicus curiae for the petitioner is present and filed here. Amicus curiae for the respondent is present and filed a petition praying for time for filing of the WS on the grounds stated therein hard. Under the case record, it is found that in spite of the grant of several adjournment filing of WS by the respondent, he has not filed the same. Today, she has also not filed the WS, from which it can be presumed that the respondent has no intention of filing of WS further. This case is a record. This case record being the allocated one as per the direction of the lower court, as so the time petition filed by the respondent detected, and the respondent is precluded from filing the WS. However, she is allowed to go to the question the witnesses, if any, edits from the side of the petitioner, put up on 22/11/2025 for hearing of the case. Apparently, this is the order matter. Apparently, there is sufficient reason, as indicated in the said order by the land judge, for precluding the opposite party in filing of the WS. On a perusal of the order sheet, it is indicates that on 17/2025, the land judge reports from the board had referred to the order passed by the coordinate bench of this court in Tier 3 so and so and so. It is fairly submitted by the land ones of the said order. This court has directed to dispose of the matter within time frame. However, it does not have a copy of the said order immediately. which is submitted by the land council for the petitioner, that is approach the land judge from the court of good for by filing the proper petition, if so advised for accepting the WS, that would be filed on 2026 without fail. If the said application is filed along with the WS, the same shall be considered by the land judge from the court of good in its proper perspective in accordance with law. So therefore, I have 28th February.
petition file kale
File sir. File that had been
petition aଜ୍ଞା
file kale accept ହେଇଗଲା
petition file କରିଥିଲେ accept ହେଇଗଲା
ହଁ file କରିଥିଲେ along with WS sir.
so you have won the case sir ଆପଣ ରହିଲେ
ସେଟା withdraw କରୁଛି ସେ withdraw
withdraw କଣ withdraw ଆପଣ ଜିତିଲା ପରେ withdraw କଣ କରାଯାଏ
କୋଉ ଯାଉ ସାର୍
ଆପଣ ତ ଜିତି ଗଲେ
କୋଉ ଯାଉ ସାର୍
ମୁଁ ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଚାପ୍ଟର ପଢୁଥିଲି
ସାର୍ କୋଉ ଯାଉ ସାର୍
ଆଗ ଯୋଉଟା ମାନେ when there is a direction for direction refusing to accept written statement ତାପରେ provision ଅଛି କୋଉ condition accept କରିହବ but ସେଇ branch ଟା ଟିକେ ମୋ ପାଇଁ ନୂଆ relatively so but I am trying to ସେଟା ଯୋଉଟା ମୁଁ ସେଇ ଅର୍ଡରଟା ଆପଣ ହେଇଗଲା ଠିକ ମୁଁ actually I could not get you initially ଆପଣ କଣ କହିଲେ ମୁଁ ବୁଝିପାରିଲି ସେଟା ଅର୍ଡର କଲା ପରେ ବୁଝି
I have submitted manner in persons to this order. I have approved the court and filed the WS in time that has been accepted. ଏଇଟା କହିଲି ସାର୍
नहीं आफ्टर अमेंडमेंट देयर इज ए प्रोविजन जेटा आपनकर स्ट्रिक्ट हे गला जे आपन रिटन स्टेटमेंट न देले से प्रोसीड करिवे बट देयर इज ए लीव वे आपनकर कोन गोटे देखेले दे कैन एक्सेप्ट द रिटन स्टेटमेंट सो अश्विनी कुमार दास फॉर द पिटिशनर para the alleged counsel for the petitioner refers to the order dated 17/2/2026 particularly paragraph 3 which records thus. There. It is now it is submitted by the alleged counsel for the petitioner that after the order dated 17/2/2026 with the observations made in paragraph 3, the opposite party in the CP, the present petitioner, CP to MAT case na CP in the CP the present petitioner has filed application along with the written statement has filed the written statement ago likhibe with application for acceptance of the written statement. So the Learned Judge Family Court has allowed the application and accepted the written statement. Stop. In view of the above, nothing survives for adjudication. The writ petition is disposed of. କିନ୍ତୁ ଆପଣ ବହୁତ ରାଗି ଯାଇଥିବେ ସେଦିନ ଜଜ୍ଙ୍କ ଉପରେ ଆପଣ ଯାହା କହିଲେ ଆପଣ ଥରେ ଏଟା ସମ୍ବଲପୁର ଆପିୟର କଲେ
ରାଗିନି ସାର୍ ମୁଁ କହିଲି
ଆପଣ ତାପରେ କହିଲେ ଯେ ସେ ମୋ କଥା ଶୁଣୁନାହାନ୍ତି ନା ଆଜ୍ଞା ଆପଣ ତାଙ୍କୁ ଚାନ୍ସ ଦିଅନ୍ତୁ ଆପଣ ତ ପିଟିସନ ଦେଲେନି ଆପଣ ଏତେ ରାଗିଲେ କେମିତି ହବ
ନେବିନି ବୋଲି ମତେ ଠିକ ଅଛି
ନେବିନି ବୋଲି କହନ୍ତି ଆଉ କଣ କୋର୍ଟ ନେବିନି ବୋଲି କଣ କହିବେ କି ଅର୍ଡରଟେ ତ ପାସ୍ କରିବେ ଆପଣ ଯେ ଏତେ ରାଗିଥିଲେ ବର୍ତ୍ତମାନ ଆପଣ ପୁରା ଖୁସି ଠିକ ଅଛି
Item 7.
डेट टा କହିପାରିବେ ସାର୍ କୋଉ ଅର୍ଡରରେ डेट ଟା ମୁଁ ଆକ୍ଚୁଆଲି ଲେଖିନି I could not get the order date କଲେ ଆଲାଉ କଲେ ପିଟିସନ ଟା ଏବଂ WS ଆକ୍ସେପ୍ଟ ହେଲା
20 ଫେବୃଆରୀ
এই অর্ডারটা কেবে হইছিল
এটা 17 লিখা
আচ্ছা 20/2/26 কোন টু লাস্টে পড়ো তো লাস্ট আগে পড়লে তো কই দিস নাই তা পূর্বট
allowed the application
by allowed application and তারপরে
accepted
হ্যাঁ by order dated 20/2/2024 স্যার 2026 এটা হলো আডাও
order
Already there in the reflected in the order, paragraph number 3.
paragraph 3
22 there man 22 ର order of the trial court
22 ନାଇଁ 22 ଭିତରେ ଦେବାର ଥିଲା ସାର୍ 22
ସେଟା ମୁଁ କୋଟ କରିବି ପାରା 3 I have quoted but trial court କୋଉ ଦିନ ମାନେ କୋର୍ଟ କୋଉ ଦିନ କଲେ ସେଟା ସାର୍ ପଚାର
ସେଇ ଦିନ କଲେ ରିସେପ୍ଟ ସାର୍
20 ଦିନ ହେଇଗଲା
20 ଦିନ ହେଇଗଲା ହଁ
ଠିକ by order dated
Sanction file police ନେଇଗଲେ ଆଉ।
ସେ ନେଇଗଲେ ଆଉ ସେ order ଜିନିଷ ଆଉ।
So Dayananda Mahapatra, senior advocate, along with Mr. J. Barik for the, Mr. Pradhan, Mr. M. R. Pradhan, I'm sorry, it's Barik Pradhan Bulbal. So M. R. Pradhan for the petition. Yes, please.
No, sir,
Mr.
yes,
G.
my
N.
lord.
Tenka, additional government advocate, OP number 1.
Whereas I'm not entering into all these matters. Only 5 sentences. One, I was granted lease. But
Yes.
for that, I deposited
Opposite
this.
parties plural.
I was granted lease for 5 years. Minor mineral concession program. There, minus I deposited some statutory amounts. For some period, I operated the quarry. For that period also, I deposited the amount. Subsequently, I was not issued the transit permit and I could not operate. Then thereafter, when a committee was constituted, they found that this whole total quarry is extinct. This cannot be operated. Thereafter, I have come before the Hon'Ble High Court. Hon'Ble High Court directed the collector to consider all this. Collector considering all these aspects, well, it's kind of a glance to that particular order. A disposal of the representation, which is Annex 2. Well, space starts from page 28.
Correct.
I'm last portion of page 30.
Yes, I'm at 30.
Page 30. Well, so there minus the allegation twofold.
Just kindly read the complete paragraph. It starts at 4 lines.
Where is?
Right.
Whereas Tahsildar Champua has further submitted that Durkulia stone quarry was granted on lease in favor of the writ petition for a period of 5 years, which expired on 7/6/2021, and this quarry has already been extended in the meanwhile. Therefore, Rule 8 such and such rule, read with Rule of the Women's Rule, is not applicable in this particular case to consider the grievance of the petitioner by Annex 9 to further extension of the lease period. The second part of the case of the petitioner is to refund the royalty, surface rent, and fees paid by the petitioner in the instance of non-extension of the lease period of the query. The Tahsildar Champua is directed, well, this is very important, directed to re-examine the issue of payment particulars and amount due for payment afresh and take appropriate steps for refund of the excess amount if paid in excess by the petitioner, and further directed to take steps realization of the amount due, if any, by the petitioner in this regard. Two concepts. One, if I am entitled to be refunded to me, if they are entitled to minus, then that will be recovered. These aspects. So it requires a determination. There is no determination. No, I have not been issued.
Sure that Tahsildar never had any proceeding.
No, but Tahsildar initiated a proceeding. There is a certificate proceeding. Tahsildar initiated.
Not certificate, the OMMC.
The OMMC related to demand.
Correct.
So demand to be decided.
So on to this order,
yes, my
collector. Your assertion is that Tahsildar never had.
No, that is my case before Tahsildar. That is what I requested Tahsildar to reconsider. Hear me. Then also decide that this is the amount can be recovered and certificate. If I will not pay, then obviously certificate proceeding will be initiated because he is the requisitioning authority, also adjudicating authority. But jehetu it amount of 10,000 more higala, 10 lakhs more higala, so it will be adjudicated by the sub collector. What he did is he drew that proceeding, one certificate, and then referred to the sub collector. Sub collector issued me the notice.
High Court order of the earlier bench.
Yes.
Is regarding the certificate case or the. Again.
That is relating to the fact that I have come before the Hon'Ble High Court.
Correct. In the minor mineral proceeding or
minor proceeding. Minor because there my case was that yes, I could not operate the quarry though I have taken it for 5 years. I may be given extension, whatever amount I have deposited, this amount may be adjusted for subsequent years, and any due, if any, I can pay.
Mr. Lenka, then how this could happen without any proceeding?
So you have to, they have to hear me then.
All these things, he could have raised before the sub-collector under section 8 of the OPD. Denial petition we could have filed, and under section 9, they are bound to consider. Instead of that, he has approached this.
No, will the sub-collector consider this? The problem, Mr. Lenka, the another problem is that the last question whoever Mr. Mahapatra has answered, that is a direction by the High Court. And collector acted upon direction by the High Court, coordinate bench. And as Mr. Mahapatra has said, that it is a minor mineral, that order is regarding the query, stone query, provisions of minor mineral. Then, in fact, the collector has passed, in fact, he has not favored him. He says that you determine because he cannot be granted extension if any amount. So the way he will calculate it is for the Tahsildar, he may be happy or that's a different thing. But now they say that nothing has happened. Straight away the demand notice. It has to be, basically this has to actually, again, wastage of your time and my time in this sense. If there is no proceeding, how can you, whether he says take this plea before the sub-collector in 8 and 9 or not is immaterial.
Whether it has been determined or not, he said, I have to take instruction.
But that you can take instruction.
I have no instruction, notice has not come.
Yes, fresh matter you could not have, but then, you know,
But
why I am saying this to you, sir? Don't keep these matters pending. This adds up to pendency. You file a counter.
Yes.
After 5 years, I will take it up for admission. I'm just saying maybe 1 year after. Because it's 26 matter, it goes down the list. On the day it is taken up, that day it is found that after High Court order, the collector takes a decision, decides, both parties are happy, he has not challenged. And after that, there is no proceeding. Then what kind of adjudication as far as the certificate case is concerned, High Court can make?
His version, all these things can be raised before the sub-collector.
No.
Well, may I submit?
He is not an authority as far as High Court. Then High Court should have directed, the collector should have directed sub-collector. On the face of it, Mr. Lenka, High Court directed collector to decide. Collector has decided and said that Tahsildar being the authority of the minor mineral rules, he will decide. Certificate cases regarding the demand and whether the demand. So if you say that if you will consider 8 and 9, definitely he can do it. But ultimately whether it can be achieved anything.
May I submit only one line? I cannot raise judge objection before under section 8. Well, kind of a class to that.
No. They are Mr. Mahapatra. If Mr. Lenka says that it is person of the opposite party,
obviously,
file that.
Obviously,
you file that. At least they will be standing by that.
We have filed there. That is not the point.
What the sub-collector will ultimately decide, that I am discussing.
But I'm not
now,
on there.
Suppose you file 8 and 9, saying that since the collector has directed the Tahsildar to determine and the Tahsildar has not determined anything.
Yes.
So whether that aspect the sub-collector can adjudicate,
that is exactly my some pointing out. Kind of a glass to section 8.
Anyway, so till he obtains instruction.
I don't have a only thing is that my London friend read that section 8 in a different way, but I'm putting it in a different way. Only in two contingency I can raise this dispute before under section 8. That one is that the certificate due have been fully and partly paid. I'm admitting that is the amount due, I'm to pay. Second contingency is the person on whom such notice has been served is not the person named as a certificate debtor. I'm not coming within the two.
But your submission is correct, but since Mr. Lenka is saying,
I don't stand in the way, man. That is that yet.
So one thing, I don't know if I mean, now going to that side, I can only add to both of you. Third thing is that you will say that the amount has never been determined.
Yes, exactly. Be determined involving me.
So let the sub-collector decide.
Involving me, and thereafter, if they found that yes, I am entitled, liable to pay something, then only if I deny, thereafter a certificate proceeding is to be initiated. Means the requisitioning authority will issue a certificate.
But right now, I am not remanding it in that stage. But I am issuing notice. Lenka, to that extent, I think he says that 8 and 9 they will consider.
They cannot.
If they say that we will consider, let him file. So you will file your.
No, my question is
and suppose you file before the certificate authority that it has never been determined against me, then what would be the finding? That neither Mr. Lenka can say nor you can say.
No, question is that then we are going by the statute. In this contingency, it doesn't arise that I cannot raise that.
No, what you are saying, there is a possible answer by the sub-collector.
No,
but you have to wait for that.
No, sub-collector is now.
Sub-collector, if he rejects, he rejects your application, 8 and 9 application. They are saying 8 and 9 also application, not so cause.
No, 8-9 application kata mo kahuni.
Petition denying liability, not a petition. So if he rejects your section 8 petition, no, your point is you will take Mr. Mahapatra.
Well,
Your point they have to answer.
just to add,
But but before filing of counter, we are not adjudicating.
Well,
Leave it there.
that in that way, Miles, I'm not standing in the way. Well, the only thing that is what my lords have directed in the order dated 6/4/2026. My learned friend is to take instruction, and that is all right, Miles, that is there. That is there. But my humble contention is that, well, just to let my learned friend file a counter. But my humble contention, I just reiterating the fact, here in this, well, let us understand it in a two different way. First,
So Mahapatra, to that extent, I have already informed Mr. Lenka that if the sub-collector cannot adjudicate regarding direction of the High Court and collector, this court is not in appeal with the direction of
No, that is not.
So obviously, ultimately, after 1 year also, this matter cannot be adjudicated.
Gentlemen, that rightly, man.
Take only time.
Yes, ma'am. That's rightly pointed out.
Maybe they want to help you.
That is not the thing. Now, Miles, may I point out?
Why suddenly the sub-collector and the Tahsildar, instead of following collector and the High Court, they do something which they intend to do or they like to do. So
That's a $1 million
it may be their favorite.
That's $1 million.
And the lawyer and the $1 million question and the $1 trillion question is lawyers should not be unhappy. What Mr. Lenka will do and what he will do.
That is there in judicial process.
Yes.
Not there Miles before the
Why
administrative.
this they don't follow the High Court order or the collector's direction? That is a following High Court order is another thing, but also not listening to collector is another thing.
But now,
but there Mr. Lenka is categorical that he has to obtain instruction whether
I don't stand in the
actually there is any pursuant to direction by the collector
whether
by complying High Court's order. So whether they have determined or not,
no, that exactly.
How he will say that.
No, he cannot unless and until take instruction. He cannot say.
You allow him that time.
No, that I don't stand in the way. Just stand to clarify the position.
No, I am not saying that you have to file 8 and 9. Please don't take it that way. Perhaps you are anxious because I am asking that you have to file 8 and 9. That is a submission.
No.
That is his.
The first line also made it clear.
Yes.
A counter is required for the purpose.
That is his submission because now I am confronted with a High Court order also. Yes. Had a senior advocate for the petitioner at some length. The learned AG in response, the learned AG has also made his response. But though the matter was listed for fresh admission on 6/4/2026, had being adjourned by the learned instructing counsel for the petitioner, the learned advocate on record for the petitioner in the court. To obtain instruction, the learned AC also had adjournment to obtain instruction. It is submitted by the learned counsel for the learned senior advocate for the petitioner refers to the earlier order passed by the coordinate bench, not division bench. By the division bench. Dated 24.01.22 in WPC number 1306 of 2024. Division bench. Copy of which has been annexed to the present writ application marked at Annexure 1. It is submitted. It is submitted. The senior advocate refers to the operative portion of the order. Paragraph 7 achi, page 26 court copy. The collector takare consider kale full page.
Annexure 2 minutes. Page to start from page
1 to the said order by the division bench. The collector has taken up the matter and passed. And after hearing itala. After hearing the parties by order dated 21/8/2024, he has passed the following order with directions to the Tahsildar. The operative portion thereof is reproduced herein. The para page 29
starts from 29 and
whereas Tahsildar Champua up to page 30 Soruchi. intimate all concerned accordingly. Again, last line, last paragraph, last subparagraph, numbering nine.
No, number. Last part.
Last paragraph. It is categorically submitted by the Learned Senior Advocate upon instruction that pursuant to the order of the collector, in compliance of the order of the division bench in the writ application, there has been no further proceeding before the authority, that is Tahsildar. Tahsildar ko jaga seta? Tahsildar, Champua, for determination of the amount that may be due to the state or to the that may be receivable by the petitioner. Stop. The petitioner was the petitioner was leaseholder for the Durukulia, DURU, KULIA, Durukulia stone quarry under the Champua Tahsil. Stop. Stop to comma. Which is the subject matter? Which is the subject matter before the division bench, as well as the adjudication by the collector as directed by this court. Stop. It is submitted that without determining the amount due in any manner,
giving opportunity of hearing to me matters,
and without giving any opportunity of hearing, the authorities have proceeded to recover the amount.
Well, initiated proceeding.
The authorities have initiated the proceeding
under OPDR.
So, initiated certificate,
proceeding under the provision of
OPDR.
Orissa Public Demands Recovery Act, into bracket OPDR 1962, which is pending adjudication
before the
sub-collector Kendujar. He being the authority defined under the statute, under the said statute.
Sub-collector Champua.
Sub-collector Champua. Kendujar. Sub-collector Champua. Stop. Para. Issue notice along with this order. The Learned AG upon advance copy served appears and waives notice on behalf of the opposite parties. It is submitted by the Learned AG in response that he has to obtain instruction and file affidavit regarding the averments made in the writ petitions and also the submissions made by the Learned Senior Counsel for the petitioner. Stop. Wait notice accordingly, counter affidavit on behalf of the opposite parties be filed within 6 weeks. Within 6 weeks, upon serving copy thereof on the Learned Counsel for the petitioner. Stop. IE 3602 of 2026. Had done it senior advocate for the petitioner. He reiterates his submissions as noted above. Stop. Issue notices above. Stop. The Learned AGA upon advance copy served appears and waives notice on behalf of the opposite parties. He shall obtain instruction and file counter if so advised. Stop. As an interim measure, it is directed the proceeding.
Annexure 3 matters.
Proceeding
in Annexure 3.
In Annexure 3,
yes,
pending before the shall be adjourned to a date beyond beyond 13/7/2026 upon a prayer being made for the said purpose.
Yeah.
The matter shall be listed in the week commencing 6/7/2026. Listed. Orders na admission, Mr. Lenka. Orders na admission for admission. Okay. Listed for orders. But if you are not satisfied, you better they should do it again, because otherwise at the end of the adjudication nothing will happen for the revenue.
ଗୋଟେ ଦେଖିଲି ଯେ ସବ୍ କଲେକ୍ଟରଙ୍କ ଯୋଉ ନୋଟିସ୍ ସେଥିରେ ଗୋଟେ କଥା ଲେଖା ହେଇଛି, ଯେହେତୁ ତାଙ୍କର ଟ୍ରାନ୍ସଫର ହେଇଛି, ସେ ଲେଖିଛନ୍ତି ଟ୍ରାନ୍ସଫର ୱାର୍ଡ ଲାଙ୍ଗୁଏଜ
ଆପଣ ଆଣନ୍ତୁ।
ନାଇଁ କନଫ୍ୟୁଜନ ଟା ହଉଛି 10 ଲକ୍ଷ ଟଙ୍କା ଭିତରେ ହେଲେ ତହସିଲଦାର will be the requisiting authority and adjudicating authority.
10 ଲକ୍ଷ ଟଙ୍କା ହେଲେ 10 ଲକ୍ଷ ଟଙ୍କା ହେଲେ ସବ୍ କଲେକ୍ଟର ତାପରେ ଏଡିଏମ୍
ତାପରେ ତେଣୁ ସେଇଟା ସେଥିପାଇଁ ତହସିଲଦାର କଣ କରୁଛନ୍ତି ପଠେଇ ଦେଇଛି ସାର୍ଟିଫିକେଟ। ମୋ କେସ୍ ହଉଛି ସାର୍ଟିଫିକେଟ ପୂର୍ବରୁ ମତେ ଶୁଣିକିରି କେତେ ଆମାଉଣ୍ଟ ହଉଛି କଣ ହଉଛି ଡିସାଇଡ୍ କରିଥିଲେ, ଜିନିଷଟା ଏଇ କଲେକ୍ଟର ଅର୍ଡରଟା କମ୍ପ୍ଲାଏ ହେଇଯାଇଛି।
Item 8.
May I please, ma'am?
Yes, please.
Madam, I am against the order passed by the family court before this.
Have you gone through the order?
Madam.
17-4. Just place it again. 17-4 order type ଅଛି ନା ନାଇଁ paperless ରେ ଦେଖନ୍ତୁ।
Paperless, I'm totally unable to go through. I'm unable to operate.
ଆପଣ ବିଷୟ ପଢିବେ ପଢୁନା ଆପଣ choice, it is your choice, but you must use.
Madam.
Younger generation cannot avoid this ICT. ଆପଣ ମାନଙ୍କ ପାଇଁ ହେଇଛି ସେଟା।
Again. Madam, last paragraph 10.
Part 1 ରୁ ପଢନ୍ତୁ।
Starting to.
Or else ସେଦିନ ଯୋଉ 1 hour 10 minutes will be wasted again.
Again, sir, କରିଛି again. କିନ୍ତୁ para 10 ରେ specifically quote କହିଲେ ଯେ it has further to be noted that order 6 rule 17, order 1 rule 10 have been relied upon by the petitioner himself to seek relief from the court, and after he has failed in his endeavor, as one of the application have been rejected, he cannot turn around and say that principles contained in order 6 rule 17 is not applicable. In any event, assuming that amendment can be allowed, it has to be within the parameters of provision of order 6 rule 17. At this stage, land counsel for the petitioner 6 and has adjourned to argue further, as he hopes he has improved upon the case heard today for 1 hour and 10 minutes. The matter shall be listed for fresh admission.
ଆପଣ ବାବେଲ ଯୋଉ lecture you should check the English language. ଆପଣ you are committing blunder in your readings. The chicken curry is poured to bowel. Bowel first it's a
BOW.
ଆପଣ bowel has been written 5 times.
Again, ନାଇଁ ମାନେ ରାତିରେ ଯେହେତୁ
କଲେକ୍ଟର lecture ରେ ତାଙ୍କର ସେ ଦେଖୁଥିଲେ ତାଙ୍କର ଗୋଟେ ଭୁଲ ଲେଖା ହେଇଛି।
Again.
So କଥା ହଉଛି ଯେ ଭୁଲ but not this kind of gross mistakes.
Again.
But ସେଟା that is besides the issue. I don't know. That is besides ମୁଁ ଯେଟା ମନେ ପଡିଲା ସେ spelling mistake କଥା।
Again.
ଆପଣ ଯୋଉ ସେଠି ପାଏ। Yes.
My lord, may kindly see all this issue arises when the cross examination in 125 CRPC is during that proceeding, my lord. So my lord, may kindly see
again, that is how I said that you have to
para 6 and 17 of readings with
now this is a 6-page order.
My lord.
You have to read from the para 1.
Then
so if you, because now you are saying that something is happening in 125 CRPC, so that is how I want amendment of pleadings in the CP. 13 CP.
From the date of knowledge, so my lord, I confine on to order 6 rule 17.
Date of knowledge is different. ଆପଣ petition ଟା ଆପଣ ନ ପଢିଲେ ସେଇ problem ହବ. You have to read with some concernation, because order also lot of effort is made, lot of 1 hour 10 minutes is heard from you. So kindly read again 17-4-2020 order. Para 1 ରୁ ପଢନ୍ତୁ, so that you don't veer off the track.
ନାଇଁ ତାହେଲେ beyond limitation, beyond the limit of order 6 rule 17, I am confined myself. My lord, may kindly
17 beyond jurisprudence developing. In India, amended CPC and family courts have not gone order 6 rule 17.
Within order 6 rule 17, I confine myself.
ନାଇଁ ଆପଣ ପଢି ଦିଅନ୍ତୁ ପୁରାଟା. So spend some ଆପଣ
ତାପରେ କୋଟା ଉପରେ କହିବେ କି ଏତେ ଆଉଥରେ ଟାଇମ ଟା ୱେଷ୍ଟ ହେଇଗଲା.
No, you have already, we have spent 1 hour 10 minutes. It's court's time, and that day it was break bench also. We could resume the proceeding at 3 and then continue. Please read.
Order 17-4-2020.
Yes.
The petitioner husband is the plaintiff in MAT case number Itna before the Honorable Judge Family Court Bargat. He filed application under section 13 of Hindu Marriage Act. The said civil proceeding being presented in the year 2024 for grant of divorce decree of divorce and dissolution of marriage solemnized between the parties on 25/4/2007. The ground seeking the divorce is under Section 13 of Hindu Marriage Act, alleging adultery on the part of wife and cruelty towards the husband. After filing of the application, the alleged adulterer has been implemented as a party for filing application under Order 1. Thereafter, application.
ତରବରରେ କାଇଁ ପଢୁଛ କି? Too many words.
Again?
Concentrate कर तौर ही पढ़ो नहीं इतना जल्दी में पढ़ रहे हैं तो आप कुछ भी पढ़ रहे हैं कुछ वर्ड्स नहीं है आप उसको ऐड करते हैं प्लीज कंसंट्रेट has been implemented as a party
by filing application under Order 1 Rule 10 CPC. Thereafter, application dated 9/2/2026 under Order 6 Rule 17 CPC was filed seeking amendment of pleadings as per the schedule appended to the application. The learned judge family court has dealt with the content of the parties in Order 6 Rule 17 CPC application at length and has dismissed the same. The operative portion also including the reason given by the learned judge family court is reproduced herein. Peruse the petition filed under Order 6 Rule 17 CPC and the case record in hand. It has seen petitioner has instituted the suit under Section 13(1) Roman 1 of Hindu Marriage Act with a prayer for dissolution of his marriage with the respondent, though a decree of divorce on the ground of adultery.
decree of divorce.
Decree of divorce.
Through, not though. Through a decree of divorce.
Through a decree of divorce on the ground of adultery. In the plan, he has alleged that respondent number 1 has extramarital affairs with respondent number 2, Kranti Sahoo, and on his prayer under Order 1 Rule 10 CPC, respondent number 1 is added
2,
as
not 1, 2.
Respondent number 2
Yes.
is added as a party to the suit on 27/1/2006. Prior to that, he had filed his examination in chief in shape of affidavit on 7/10/2024. Petitioner husband, though the petition under Order 6 Rule 7
Through the petitioner.
through the petition under Order 6 Rule 17 CPC is further found to have developed a new story that during continuation of the marital relationship, respondent number 1 had also extramarital affairs with one Bengali Babu, the village quack. It reveals from the petition filed that petitioner had knowledge about the affairs of his wife, respondent number 1, that is respondent number 1 with Bengali Babu, he having knowledge about the affairs of his wife with Bengali Babu and had narrated the same in the original plan.
Had narrated, no, had not narrated the same.
Had not narrated the same with the original plan. Admittedly, petitioner the proposed amendment has intended to insert 10 new paragraphs and 20
ଭଲ ଅଛି ଆପଣ ତ ଠିକ ଅଛି ସେଟା ଇଣ୍ଡେଣ୍ଟ ହେଇଗଲା intended ଟା
indented.
ସେଟା indent what is wrong
Intended to insert 10 new paragraphs and 20 sub-paragraphs in the original plan and thereby attempt to create a new story. If the proposed amendment is allowed, it would change the nature and character of the suit, be that as it may, trial of the case already has been commenced by filing of affidavit evidence on 7/10/2024. In the circumstances, prayer under Order 6 Rule 17 CPC is rejected sans merit.
Okay, then read 4. 4 is this quote, yes.
Undisputed facts are that the petitioner has filed this application, this evidence in the shape of affidavit on 7/10/2024. Then his prayer for filing application under Order 1 Rule 10 CPC was allowed by the learned judge family court by order dated 27/1/2006. One Sri Kranti Sahoo added as respondent number 2 and the application under Order 17 CPC for a specific amendment was filed on 9/2/2026. The prayer for amendment of the pleadings invoking the Order 6 Rule 17 CPC has been rejected on the ground that the trial has commenced when the petitioner husband had filed his examination in chief in shape of affidavit on 7/10/2024. It has been further observed by the learned judge family court that the petition under order 6 rule 17 CPC shows the petitioner alleged had knowledge about the affairs of his
Alleges, not alleged. Petitioner alleges.
alleges he had knowledge about the affairs of his wife, respondent number 1, in the matrimonial case with Bengali Babu.
One time he
Again.
That's a mistake in mine.
No, my lord, there is typo mistake, my lord.
Yes.
Bengali Babu, it has been further noted by the learned judge family court that the petitioner has been on his own account stating that he was having knowledge about the affairs of his wife with Bengali Babu and not narrated the facts in the original plan. The order 6 rule 17, the civil procedure code, which has been relied upon by the plaintiff seeking amendment, has defined bearing on the adjudication of the matter.
Has definite bearing on adjudication.
Definite bearing on the adjudication of the matter by this court and is reproduced herein. Amendment of pleading. The court may at any stage of the pleadings allow either party.
Proceedings. In the stage of the proceedings.
At any stage of the proceedings.
Allow either party
to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that, in spite of due diligence, the party could not have raised the matter before the commencement of trial. This court does not find any error in the findings of the learned judge family court. It has to be further observed that the proviso to order 6 rule 17 of CPC would have significant impact bearing on the case at hand. The proviso mandates the responsibility of the trial court to come to conclusion that in spite of due diligence, the party seeking amendment could not have raised the matter before commencement of trial. Now, perusal of schedule of amendment in the application under order 6 rule 17, which has been annexed to the petition marked as annexure 4 at paragraph A to J, to indicate that petitioner has gone at length to narrate, even attributing his personal knowledge, as he has narrated his version of instances of cruelty. Those are the happening which are and were within the knowledge prior to filing of mad case. The incidents which he has knowledge, which has been narrated, alleging adulterous conduct of his wife, were well within his knowledge before filing of the plan, before filing his evidence in affidavit, and also filing the order 1 rule 10 implementing another alleged adulterer a party. As an alternative submission, it is submitted by the learned counsel for the petitioner that the Code of Civil Procedure would not be applicable strictly to the proceeding under the Family Court Act. In this regard, the Family Court Act would have been bearing and in reproduced hearing.
Would have bearing and is reproduced.
Would have bearing and is reproduced hearing. Act of the provision of the notwithstanding anything inconsistent therewith contained in any other law for the time being in or in any instrument having effect by virtue of any law other than this act. The alternative submission noted above has to be rejected in as much as the procedural law guiding the procedure before the family court is governed by CPC. The definition clause 2E includes the CPC and is reproduced herein. Definition: all other words and expression used by not defined in this act and defined in the Code of Civil Procedure 1908, 5 of 1908 shall have the meaning respectively assigned to them in that code. It has further to be noted Order 6 Rule 17, Order 1.
So para 10 you have already paid. So now the question is that what remains? What is your any other submission?
My lord. There are three decisions which I want to cite it before this honorable court. Life Insurance Corporation of India versus Sanjeev Builder Private Limited on 2022, my lord.
So that has been followed by?
Honorable Supreme Court.
That has been followed by Odisha High Court in?
Many of the cases it is followed, my lord.
Have you checked any Odisha High Court decision?
My lord, वो मैंने check नहीं किया. Madam, kindly see para 70.
पढ़ा होता.
हाँ मैंने पढ़ा है.
So Sanjeev Builder has been followed by Odisha High Court in this maritime suit. Sanjeev Builder, that straight away go to the paragraph where it
Paragraph 70, ma'am.
Paragraph 70, the second portion. Okay, you read the paragraph 70 in totality.
Our final conclusion may be summed up thus. Order 2, Rule 2 CPC operates.
Read slowly there.
My lord, slowly.
So that because you are missing so many words.
Sorry, my lord.
And pronouncing so many, introducing so many and or past tense.
My lord, because I am just before on this honorable court, that's why. My lord, para 70. My lord, may kindly please.
Please.
My lord. Order 2, Rule 2 CPC operates as a bar against a subsequent suit if the requisite condition for application thereof are satisfied and the field of amendment of pleadings call for.
I think you have to reduce your anxiety. Be comfortable. Be comfortable, be composed. I have seen greatest lawyers like, they even think a voice be subhi. Justice P.C. Mishra, I have not seen him as a lawyer, but I appeared him much after he retired as in arbitration. So Mukherjee.
Again.
Mr. Mishra too, I have seen because I used to go to see his appearance. Very softly, fully coherent. Actually, it's intended mistake. No, anxious most likely that is happening. Don't be anxious. Be comfortable.
Madam. The plea of amendment being barred under Order 2, Rule 2 CPC is thus misconceived and hence negated. Roman 2, all amendments are to be allowed which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side.
Injustice, prejudice,
Seta injustice or prejudice, mane jodi Agya. Mane Order 6, Rule 17 रे भी अच्छी जदी हमें मने proviso part रे.
Proviso नहीं Upon just pardon that has been underlined by this court. 17 after देखो say page para 6 देखो. ଏବେ ଯୋଉଟା ଆପଣ କୋର୍ଟ ପଢୁ ନଥିଲେ
ଆଜ୍ଞା
ଲାଷ୍ଟ ଅର୍ଡର ଦେଖନ୍ତୁ para 6 ପଢନ୍ତୁ
the quoted by Leonard J.
provision ଟା ଯୋଉଟା କୋର୍ଟ ଦେଇଛି fourth line ରେ ଦେଖନ୍ତୁ on such terms ପାଇଲେ 17 ପାଇଲେ amendment of critics
oh man sorry
जो ऑर्डर का पढ़ुले बर्तमान 17.3 जो ऑर्डर का पढ़ुले जस्ट लास्ट ऑर्डर टा देखो तो para 7 पढ़ो
again para 6 para 7 the court does not find any error
6 so
para 6
para 7 order 17 टा report is actually order 6 rule 17 court is
again
पढ़ो
the order 6 rule 17 the civil procedure code which has
no
amendment of pleadings. The court may, at any stage of the proceeding, allow either party to alter or amend his pleadings in such manner and on such terms as may be just.
Stop there. So say just what the request, and that has been underlined by this court also.
My lord.
ठीक है. Now go back to LIC.
Again. all amendments are to be, which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. This is mandatory.
That is a very, very, very important aspect
My lord.
where you have failed actually.
No, my lord.
What has happened? What has happened after comments made, because now you are not arguing that point. Because your point is that the suit has not started. Comments.
Only
Commencement, so you are saying that only filing of affidavit is not started, but the suit.
in that regard also I have a judgment, my lord.
So now the problem is that what is within your knowledge you are now saying, and you are on affidavit you are saying it was within your knowledge, but you have not mentioned.
My lord,
That is how it is unjust.
My lord.
Now read the LIC further.
This is mandatory as is apparent from the
You have to
use of the
continue
word.
after recess because it will not be complete in 5 minutes. We will be extending the time. So after recess we will continue.
My lord.
Yes.
11 पर प्रेस नोटिस फाइल करिया था 2 weeks टाइम में भी एंटर्ड आई विल फाइल
11 ରେ ଆପଣଙ୍କ ତ ପାୱାର ନାହିଁ ମିଷ୍ଟର ଦାସ କ
नहीं सर ए आस्तिले मुको कहल
अच्छा ଆପଣଙ୍କର
सर
सर योर नेम आउटर कहि दियौ
पीके बेहरा
हाउ मच टाइम सर
2 weeks
2 weeks ठीक है so any other matter you are seeking action में
My lord, 41 permitted to withdraw with rebut to avail the amnesty benefit.
again sorry आउटर कहले
The ESI corporation, my learned friend is there. Amnesty scheme ଗୋଟେ କାଢିଛନ୍ତି ସେମାନେ.
नहीं amnesty ଆପଣଙ୍କ ପାଇଁ ନୋଟିस ପାଇଲେଣି କି
ହଁ ଦେଇଛନ୍ତି ଚିଠି ମୁଁ ସେଇ ଅନୁସାରେ
ତାହେଲେ ସେଟା ଡିସ୍ପୋଜାଲ ହେଇଯିବ ସर
पिटिशनर आपको फाइल बनाए
ମୁଁ ଆଇଟା
କରିନାହାନ୍ତି କି
ना तो
ଆଇଟା
लिस्ट को आसिनी
କରିନି ଫାଇଲ ହେବ ଆଜି
ତାକୁ ଦିଟା ଆଡ କରିବେନି କେତେବେଳେ ଫାଇଲ କରିସାରିଲେଣି ଫାଇଲ କଲେ ସେ କହିଲେ କୋର୍ଟ ମାଷ୍ଟର ଆଣିବେ ନା ଆଉ
ଏଠି ତ
ଫାଇଲ ନକଲେ କୋଉଠି ଆସିବ
ଏଇଠି ଅଛି ଦାୟିତ୍ୱ
ମେମୋ ଦେଲେ ହବ ମିଷ୍ଟର
माइलॉट में पास
ତାହେଲେ ମେମୋରେ ଫାଇଲ କରନ୍ତୁ ଫାଇଲ କରି ସାର୍ କପି ଦିଅନ୍ତୁ
ଆଜ୍ଞା
ଦିଟା ବେଳେ ହବ
ହଁ
ଠିକ ଅଛି ଡିସ୍ପୋଜାଲ ଯୋଉ ଆମନେଷ୍ଟିରେ ଡିସ୍ପୋଜାଲ ସେଇଟା କହୁଛୁ ଆଇଟମ 41 କଣ ସେ ଆମନେଷ୍ଟିଟାକୁ ଗୋଟେ ମେମୋ ସାଙ୍ଗରେ ଫାଇଲ କରିକି ଦିଅନ୍ତୁ
चिठीटा आपण पाइथि चिठीटा
मेमो सागर फाइल करो यस Yes, madam, you are placing LIC.
Madam. May I continue, madam?
Yes.
Roman 2, para 7, Roman 2.
Yes.
All amendments are to be allowed which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. This is mandatory, as is apparent from the use of the word shall in the later part of the Order 6, Rule 17 of the CPC. Then 3, the para for amendment is to be allowed.
Prayer.
The prayer for amendment is to be allowed.
Don't be anxious for reading it.
Sorry, madam.
Create lot of problem.
Madam.
The real problem is that when you read wrongly, you start arguing. It may just end up with the opposite point.
Madam.
Many times how it happens that the exact decision which will oppose your case that is cited. Because in the first reading, it appears that it is in your favor. But obviously the court on the other side, they will find that the case is on the Mr. Ray, that he thought with the memo.
Madam.
So just since it is a hearing matter, we are taking up. Let me pass this order.
Madam.
Kindly bear with me.
And my lord may pass order as per my lord in WPC number 25,035 of 22. 25,035
25,035 ଦୁଇରେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି।
ହଁ 2022 ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି 25/3/2026 25/3/2026 ରେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି।
Dr. Mr. Gopal Prasad Jela for petitioner. So, Amarendra Prasad Ray for the wherever Mr. Ray, these matters are pending.
My
So
lord,
that wherever you have issued amnesty and matters are pending, just file memo.
my
So
lord,
that your burden and the pendency is it's neither here nor there. So better this matter should be going back to you for consideration of that. So just ask your office. They are the ESI corporation to do that actually. They will do it because it is on your part. It is impossible to monitor.
my lord, we can file, but
No. You give the memo. I'm not saying filing. Just give the memo
my lord,
because related with this state.
my lord, my lord.
IA not necessary. Why we should file IA? Because pending matter you need not because you are the authority. So if you can actually take
That is the procedure, my lord. That is procedural,
procedure. Whoever can. So let the matter be listed.
my lord.
So that you are sure that these matters you have issued amnesty notices.
My lord, my lord.
If the petitioner is not responding, also it can be disposed of.
My
no point in keeping the matter pending.
my lord.
Scheme is for all.
ନା
ନା
ଏଇ ତ ସାର୍
ଦେଇଛନ୍ତି
ସକାଳ ରିଭିଜନ ଭଳିଆ ହେଲା କୋଉଠି ହଲ୍ ଟା ଟିକେ ପଢିବେ ଆଜ୍ଞା ହଲ୍ ଟା ମୁଁ ବର୍ତ୍ତମାନ ପ୍ରାୟ ହେଇଗଲାଣି 6 ମାସ ହେଲା ଖୋଜୁଛି ମିଷ୍ଟର ରେଇ ବି ଖୋଜୁଛନ୍ତି ହଲ୍ ଟା ହେଇଥିଲେ ଏବେ ମୁଁ କହିଥାନ୍ତି ଯୋଉଥିରେ ଆପ୍ରୁଭ୍ କରିଛନ୍ତି ଲିଷ୍ଟ କରନ୍ତୁ ବୋଲି ଏଟା ହଲ୍ ନୁହେଁ ଏଟା ସ୍ପେସିଫିକ୍ ତାପରେ ତାର ଗୋଟେ କଟ୍ ଅଫ୍ ଡେଟ୍ ବି ଅଛି ସାର୍
30 ନା 26
ନାଇଁ 31st March 25
1/10/25 30 ନା 26
ନାଇଁ
Scheme
ସେଇଟା
ଟା।
ଆଉ ଗୋଟେ ଜିନିଷ ସାର୍
ସେ ସ୍କିମ୍ ଟା ଅଛି ନା
ସ୍କିମ୍ ଟା ସେଇଟା ସେଇଟା ଆଉ ଗୋଟେ ଜିନିଷ ଗୋପାଳ ପ୍ରସାଦ ଜେନା ଫର ଦ ପିଟିସନର So, Amarendra Prasad Ray for standing counsel for opposing parties. The matter being in the list is mentioned by the relevant counsel for the petitioner, referring to the instead by the petitioner stop the relevant counsel for the petitioner refers to memo of date which is filed in court enclosing the letter dated 18/2/2026 issued by the regional director ESI corporation of opposite party. Stop. Copy of the memo has been served on the relevant standing counsel. Amarendra Prasad Ray, who usually appears for the opposite parties. And Mr. Ray, relevant counsel being present in the court shall appear for the opposite parties. He shall find his local authority with him. Already filed or not?
already filed, but my name
He has appeared. He has filed his local authority to the Manpur.
file देखिए कोई 25 ରୁ file कलेनी
Such an appear for the opposite parties. He submitted by the relevant standing counsel that he has filed his local authority, but the same is not reflected in the cost list. Physical which is not reflected in the cost list. It's case window that the it out of the resolution. So the disclosure order. अगर ये मेमो का लिख ले मेमो फेक सीट रिचर्ड कर दे तो मेमो इज टेकन ऑन रिकॉर्ड अपॉन कंप्लीशन ओके ठीक है तो अपन लिख ले यस फाइल इज लोकल नाउ on verification of the records available is found that the local number has not been tagged to the case screen So, registry shall do well to look at the same to the case fee.
ମାଇଲଟ में से फ्रेश बकला था
Okay.
एप्रिल 2025 रे फाइल करथिली पर्टिकुलर डेट मन नहीं
Record. Registry shall do well to look at the Okalaknama and act the same to the case fee. Can copy, shall to update. The Lorded Standing Council has the liberty to file duly executed Okalaknama as it is stated. Duly executed Okalaknama again. As it is stated by the Lorded Standing Council that he had filed Okalaknama April
2025.
2025. And there is a possibility of the state Okalaknama being misplaced.
Right.
Okay. How to mention matter? Like
माइलर item 9 the new matter.
Madam Sharma, can we go through the fresh admission wherever is possible to complete and then you start yourself?
Madam, may kindly explain this matter?
So, there is a purpose. The reason being that since it is in the wherever the suit is interdicted by a proceeding, the court's endeavor should be that it should be disposed of. Because you have a case there whether you may challenge this or and you may whatever available material is there, you complete your pleadings and proceed in the suit.
No, pleadings are not completed.
Whatever you do. So that is your choice. So that is the purpose in not keeping the matter when there is no private case. Yes, Mr. Mishra.
Lordship.
Lordship, I am Mr. Item 9. Mr. Aditya Mishra for the petitioner. Petitioner is the company. The petitioner is the company registered under the
proprietorship, sir.
The petitioner is a proprietorship concern engaged in
petty labor works, like
Contractor.
engaged in providing labor contract.
Contract job.
Engaged in contract job. Has approached this court challenging the notice or challenging the order dated 9/12/2025 passed by the authority, ESIC authority under section 45 of the ESI Act for the period from 1 January 2024 to June 2025. Thereafter, order has been passed dated 19/2/2026 by the opposite party ESIC authority directing recovery under section 45 into bracket capital C to section 45 into bracket capital I of the ESI Act along with interest for an amount of rupees
6,22,525.
6,22,525, which is also under challenge. Yes, what is the grounds of challenge, Mr.
Lordship, here is that I have not been heard in the matter. They had issued notice in the address of the principal employer, that is L&T, where I have already left since December 2023. It was only in February 26 when I received this letter 19/2/26. I approached them and wrote to them that I may be heard in the matter and my establishment has closed its work in Odisha since December 2023. So they said this is a recovery proceeding, we cannot help. Accordingly, Your Lordship, I sought for the documents, that is Annexure 5 on 7/4/26. So in the process, Your Lordship, I have deprived of being heard.
It is submitted that challenging the order, it is submitted by the Lord Council for the petitioner concerned. that before passing the order, he has not got any opportunity. The petitioner has not got any opportunity of hearing to respond to the demand. He submitted that the notices were issued to the principal employer.
Address of the principal.
Notices were issued in the address of the principal employer, from which the petitioner has closed his at which the petitioner has closed his work and left since
December
23. Issue notice along with this order. ଆପଣ जो ଗାର୍ନିସି ଅର୍ଡରଟା ହେଇଛି ବ୍ୟାଙ୍କକୁ ପାର୍ଟି କରିଛନ୍ତି?
ନା ଗାର୍ନିସି ହେଇନି। ଇଏ ସାର୍ଟିଫିକେଟ ପ୍ରୋସିଡିଂ ଆରମ୍ଭ ହେଇକି ଡିମାଣ୍ଡ ନୋଟିସଟା ଯାଇଛି ଅଣ୍ଡର ଆନେକ୍ସର 1।
Issue notice along with this order.
Recovery officer is a party.
Mr. Amarendra Prasad Ray, standing counsel who usually appears for the opposite party corporation, shall accept notice on behalf of the opposite parties.
My lord.
How many extra copies?
One extra copy.
One extra copy of the application shall be served on Mr. Ray, counsel, on a standing counsel. Within 2 working days? Yes. Within 2 working days. Stop. Mr. Ray and associates shall file their wakalatnama
within 15 days.
Within 15 days. Within 15 working days, stop. Upon filing of the wakalatnama, the same shall be taken on records. Scanned copy be updated. Stop. The standing counsel shall obtain instruction and file counter if so authorized.
My lord.
IA 7029 of 2026. Like the IA hard direct counsel for the petitioner reiterates his submissions as noted above. Stop. Para. So Amarendra Prasad Ray shall accept notice on behalf of the opposite parties as let one extra copy be served within 2 working days. In the interim, it is directed no further steps shall be taken pursuant to the notice dated 19/2/2026 and letter dated 2/3/2026.
My lord, order is 10/12/2025 and demand notice.
Order dated 10/12/2025.
Demand notice dated 19/2/2026.
And been stated 19/2/2026 till the next date of hearing. The matter shall be distributed for admission in the week commencing 6/7/2026. The interim order shall continue till the next date of hearing. Any other fresh and orders matter anyone mention? Item number 12. 1 second. I'll go seriously. 11 that.
11.
On behalf of Samir Kumar Das for the petitioner. Opposite party, Mr. Mr. B.N. Lekar, AG, for the opposite party. The matter is mentioned by the Lord Counsel for the petitioner. So, it is submitted by the Lord Counsel that he may be granted further 2 weeks to take steps for issuance of notice to the OP number 3 in the present correct address. Stop. Para. Prayer is allowed. Steps be taken within 2 weeks. Stop. Stop. No. For issuance of notice to the OP number 3 in the present. Upon filing of the requisites, the registry shall do well to issue notice to the opposite party number 3 affairs. Unutilized copies, if any. Unutilized requisites copy. Unutilized requisites, if a comma, if any, then comma, shall be utilized. The letter shall be listed for orders in the week commencing 6/7/2026. Mr. Vishwa, your matter item 12.
Lord, this is
a land acquisition appeal.
Yes.
But the original award was rupees 900 as per the order of the land acquisition officer.
Yes.
It was LM case was filed at the behest of the opposite party respondent, and in that LM case, the awarded amount was enhanced to rupees 900 per decimal, against which we preferred this. My lord, we preferred the appeal. The LM's case, the award amount was enhanced to 2,500 from 900. 900 to 2,500. We have challenged that order before the Honorable Court in appeal. Well, in the meantime, a judgment has been delivered by the Honorable Court, which my learned friend appearing for the respondent has produced. There, in respect of the same khata, the awarded amount has been, the LA appeal has been dismissed on merit. So if the same order is passed without recording my concession,
I mean, it's not a question. It's a question of concession also. It's a statement of position of law.
Yes,
Copy that here. Mr. Vibhuti Bhushan Mishra, senior panel counsel for the petitioner, for the appellant. There is no appellant. Again, the review petition, the petitioner. Mr. Abhimanyu Parda for the opposite party. ଏଟାକୁ ଆପଣଙ୍କର ମୁଁ ଅର୍ଡର ସିଜର କରୁ really possibility of time if I start dictating
it will be better. Your lordship can also go through the judgment.
ତାପରେ ଅର୍ଡର ସିଜର ଏ କପିଟାକୁ ତା ଦେହରେ ନମ୍ବର ପକେଇ ରଖିବେ ଖାଲି ଗୋଟେ ଲାଇନ ଆଡ୍ କରିଦେବେ learned counsel for the appellant sorry respondent number 3 produces copy of the order dated 11/11/2021 passed LAA number 44 of 2016. It is submitted by the learned counsel that the order in the said appeal has put to rest the controversy raised in the present appeal. The copy of the order is also served at the learned counsel, learned senior panel counsel. ଏଇଟା ତା ଭିତରେ ଗୋଟେ ରହିବ ସବଷ୍ଟାନ୍ସିଆଲ ତାକୁ ଫ୍ୟାକ୍ଟ ଗୋଟେ ଲେଖିବାକୁ ପଡିବ appearance ଲେଖନ୍ତୁ
OP number 1. OP number 1. I am for the OP number 1.
Yes. OP number 1. So पढ़ने वो डाकिनी actually. I have not dictated the ये portion. Appearance ता डाकिनी.
OP number 1 or 1 to 4. All are private party. Number 1 to 4.
एल्ले कलेक्टर को करना थी ଆପଣ ସହିତ
ହଁ କଲେକ୍ଟର
ଆପଣ ତ ଏଣ୍ଟାୟାର ଡେ ର ଗୋଟେ ପିସ୍ ଆଉ ନା ଏଲ୍ଏ ରେ ଅଲଗା ସବୁ ଏଲ୍ଏ ରେ ଗୋଟେ ଗୋଟେ ଅଲଗା ବିଲ୍ ହଉଛି ଆଗରୁ ଏଲ୍ଏ ରେ ମଧ୍ୟ ଅଲଗା ଅଲଗା ବିଲ୍ ହଉଥିଲା
That is what LA bills are sent in favor of
ହଁ ଅଛନ୍ତି ଅଛି
12.
5-6 ଅଛନ୍ତି
5-6
ଅଛନ୍ତି
5-6
ମିଷ୍ଟର ଡିଏନ୍ ଲେଙ୍କା
AC.
Abhimanyu Parda for the
Mahanti's name.
Abhimanyu Parda for 1 TO24. Mr. Prem Kumar Mahanti, additional standing counsel for OP number 5 and 6. Number पके receive करिए. Yes. Mr. Manoranjan Acharya. ଆପଣ ମିଷ୍ଟର ତ୍ରିପାଠୀଙ୍କ ପାଇଁ ଆପଣଙ୍କ ଆଚ୍ଛା ସିଏ ଆପଣଙ୍କ ସାଙ୍ଗେ ତ ଛାଡୁନାହାନ୍ତି ତ୍ରିପାଠୀଙ୍କ ଯିବ କଣ ଅସୁବିଧା ଅଛି Manoranjan Acharya for the petitioner. Opposite party none. The matter is listed for orders is mentioned by the learned counsel for the petitioner, referring to the memo filed on behalf of the petitioner, which is on record marked as flag A. So memo referring to memo dated 17/4, your matter is disposed of. Any other matter?
No.
It is allowed actually. It's jaha order thiyo seta same. Same khata plot to?
Same खाता मात्र किती है ଗୋଟେ ଖାତାର ବାଇ ପ୍ଲଟ କିଛି ଆଉ ସେମ୍ ଖାତା ପ୍ଲଟ
सबिक record समान ଅଛି ତା ମାନେ हाल खातारे बाय प्लॉट
ବାଇ ପ୍ଲଟ ସେଟା ତାଙ୍କର 22 ତ ଆମ 23
The petitioner husband is before this court challenging the judgment and order dated 26/3/2019.
My lord, so this is my turn.
ଆପଣଙ୍କର ଏତେ ଦରକାର ନାହିଁ ଆପଣଙ୍କର ଗଲା ଥର ଯେତିକି ଯୋଉ ଯାଇଛି ସମୟ ତାପରେ ଆଉ କିଛି ଆପଣ ସବମିଶନ କରିବେ
ନାଇଁ ଲର୍ଡ ଅଛି ତା ଭିତରେ
LIC ଅଛି ତ
ନାଇଁ ଆଉ ବି ଅଛି ତା ଭିତରେ
ଯୋଉଡାକ ମେନସନ ହେଇଛି ଯୋଉଡା ପିଲାମାନେ ମେନସନ କରି ପଳେଇଲେଣି
ଆଜ୍ଞା
I am completing that.
Sorry my lord for interruption.
No, it's all right. is passed by the Honorable Judge Family Court Noyagarh in CRLP number 16 of 2018. At the said judgment, the petitioner under section 125 of CRPC filed by the wife in the marriage seeking monthly maintenance. As the petition was favored, directing payment of monthly maintenance, the rate of ₹3,000 from the date of the filing of the application, 27.01.2018. The said order is challenged for this. The memo filed on the memo filed on behalf of the petitioner dated 17/4/2026 is taken on record. Scanned copy be updated. In view of the above, the petition is disposed of. Stop. Copy of this order shall be forwarded to the Honorable Judge Family Court Noyagarh to be kept in the records of CRL number 16 of 2018. Disposed of by judgment dated 26/3/2019. order locating 20 लिखो तो आपण एटा कॉपी कला पर आखर कर दिए एटा बहुत बड़े साइकिल समय नहीं तो राकेश कुमार मल्लिक for the petitioner Mr. Ranjit Kesari Samal Jit party that disposal गोटे ऑर्डर हे परि कॉस्टेटल गोटे करि करिया पड़िबो double 33340. The matter is listed for orders. It is mentioned jointly by the learned counsel for the petitioner as well as the opposite party. The learned counsel for the petitioner refers to the memo dated the memo of date which is filed The memo states thus. The petition was filed by the husband in the marriage, challenging the order dated 9/9/2025 passed by the Honorable Judge Family Court Paripada, Mayurbhanj, in CP number 262 of 2024. Stop. The said order was passed in the CP in an application filed by the respondent wife, filed by the respondent husband in the marriage under Order 7, Rule 11 into bracket small d of the CPC. By the said order, the Judge Family Court observed thus, page 18, noting the objection of the respondent up to same is rejected. One minute. In view of the statement made jointly by the learned counsel for the parties, the petition is disposed of. Copy of this order shall be forwarded to the learned Judge Family Court to be kept in the records of CP number 262 of 2024. Judge Family Court, Paripada. Yeah. ERPC. The application has been filed by the wife in the marriage seeking transfer of the CP number 161 of 2025. Pending before the learned Judge Family Court. The CP has been filed by the husband in the marriage under section 22 of the Special Marriage Act, seeking restitution of conjugal rights. Memo of date has been filed by the learned counsel for the petitioner, which is also endorsed by the learned counsel for the opposing party. Or which bears the endorsement of the learned counsel for the opposite party. The memo states thus. Stop. Stop. The memo shall be taken on record, scanned copy to updated. In view of the above, the petition is disposed of. Copy of this order shall be forwarded to Yes, since it will take some time and there is paucity of time today. So after Madam Sharma's matter, it won't be possible to open any further brief. Must understand.
I was in item 19.
So just what I can suggest that you take a date if you want, or you will adjust it. You leave it to him. The only thing is that if you want anything to go beyond vacation, because already in the 18th and 11th and 18th week,
matter is
150 matters he has.
condemnation of delay for restoration, CMA. Condemnation of delay, the matter.
Allow kar deba na kaun?
Your lordship may allow. Restored, that is 19 months.
Upon his instruction, objection.
No other instruction has come.
ଆପଣ ଯୋଉ ଆଗରୁ adjournment ଦେଇଥିଲେ କିଛି ଆସିଲେ
continuation of delay बस
ଆପଣ
516 days delay मान
516 Item 92, Mr. PC Chinchani. Leadership of Chinchani for the petitioner.
94 days.
Mr. Prem Kumar Mahanti for the opposite party 1 and 2. P3 none. The CM appeal has been filed by the petitioner seeking restoration of the WPC number 15999 of 2014. The IA Sangat mistake. The IA has been IA 429 of 2025 has been filed for condonation of delay of reported delay of 564 days.
594 days.
564 in filing the same appeal. In explaining the delay supported by affidavit, the following has been stated. Four, 5, 6. The Learned Counsel for the petitioner highlights the fact that the petitioner is a senior citizen. Now is it about 78 years, 77 years. And his case was judged sympathetically. It's further submitted that state being an ideal employer, the cases of a employee working in a college should be considered sympathetically to 6 for area.
Career advancement benefit.
Career advancement benefits.
In reader scale.
In the scale of reader. As the petitioner has retired as a lecturer in English from Anandapur College, Anandapur, which is a category 1 college. Anandapur College, Anandapur stop. The Learned Additional Standing Council, though in principle opposes the prayer for condonation of delay, but it takes a fair stand in response to the submissions made by the Learned Counsel for the petitioner. Considering the age of the petitioner, it should be treated sympathetically. Stop there. Having heard the Learned Counsel for the petitioner as the Learned Additional Standing Council, the prayer for condonation of delay is allowed. The IA is favored and disposed of. CM appeal रे सर कोन देबे आपनी किसी फाइल करिबे CM appeal से response ना wait करिबा ना CM appeal देखंतु ता पता माने CM appeal अलगा CM appeal 26025. The CM appeal has been filed for restoration of the writ application 15999 of 201425, which was dismissed for non-prosecution by the petitioner by order dated 2/1/2024 by the coordinate bench. In view of the notification of the High Court of Orissa in the administrative side dated 8/5/2025, the matter has been listed before this bench, the subject matter being within the determination. Stop. Issue notice. Stop. The Learned, as a hard Learned Counsel for the petitioner, proper issue notice. So notice पूर्व instruct करते. The Learned Additional Standing Counsel, upon advance copy served, appears and waives notice on behalf of opposite party number 1 and 2. Issue notice to the OP number 3 by speed post with registration and proof of delivery. Requisites for issuance of notice to OP number 3 be filed within 7 working days. The Learned Counsel for the Learned Additional Standing Counsel for the state shall also instruct OP number 2 regarding देखिए से appeal न कले फिर आउता चेष्टा करिया पड़े list after SR, liberty to mention.
Madam, item 16 permitted to withdraw on behalf of Mr. Jayanti Naik.
ଆପଣଙ୍କ ନାଁ ସାର୍
ନାଇଁ ମତେ
ଆପଣ ତ ନାହାନ୍ତି ଆଜି
ମୁଁ ତାଙ୍କ ଆସୋସିଏଟ ନୁହଁ ମାରେ ମତେ ସେ ଖାଲି କହିଛନ୍ତି
ତାଙ୍କ ଦସ୍ତଖତ ଅଛି
ମାଇଲର୍ଡ My lord, earlier notice on admission was also issued by the order dated 13/10/25. By another coordinate bench.
This page. The allotted additional standing counsel is apprised of the order dated 2/2/2026. This shall be provided with a copy. Upon copy darkar 2/2/2026, wherein he was requested to obtain instruction from the Director of Higher Education as to how the OP number 3 is not responding to the notices issued earlier by order of the coordinate bench dated 13/10/2025. ଆପଣ ନ କହିଲେ ସେ ଆସିବେନି ବୋଧେ ଲାଗୁଛି ଆପଣ ତାଙ୍କୁ ଉଠିବାକୁ ପଡିବ କଣ ଗୋଟେ କରିବାକୁ ପଡିବ
In the read petition also they had not appeared. I had taken notice twice.
पर्सनल अफेयर ताको आणे पड़ो
Governing body.
नले वारंट करे पड़ो अपन
Governing body रो ताका
आउ तो किसी फॉर्मली करी होबनी
So should I again take notice? My lord, in CMA.
नहीं नोटिस आपण सीएमएफपी ले नेबे आपणकर डिले कंडन हैला परे
आज्ञा
आपण अथरे नियम
प्रेस नोटिस
हां आपणकर लिमिटेशन और एडमिशन टीचर नोटिस इशू हेइतला बट कंटिन्यूएशन हैला परे आउसरे हियरिंग पई तो दिल्ली तो करे पड़ो सो द गैप इज देयर
The college will not appear. That is
they will not appear. They will not appear. So, I mean, law knows how to do it.
And probably in this reader scale up, they don't have any role to play. It is for the government and the direct.
Let them play their role.
Again.
But law will take its course. Whoever is playing whatever role, it's up to them. If they choose not to appear, they will be taken care of.
item 17. 16 withdraw on behalf of Mr. Madam Jayanti Naik.
Mr.
SS Das.
SS Das.
I am not her associate.
For the petitioner. 16. Miss Jayanti Panigrahi.
Jayanti Naik. Jayanti Naik.
She is not the only Jayanti, sir. Miss Panigrahi is here. Jayanti Panigrahi on behalf of the opposite party. For the opposite party, the Ms. Panigrahi been present at the virtual court, High Court of Orissa, Hon'Ble at Fulbani, addresses arguments. On 28/1/2026, the order was passed after hearing the learned counsel for the parties. Reproduced document. Today, the matter being in the list is mentioned by the learned counsel for the petitioner. Memo of date is filed, which states thus. So, memo shall be taken on record. Scan copies are updated. In view of the above, the petition is disposed of. Copy of this order shall be forwarded to the learned Judge Family Court Fulbani to be kept in the records of CRP 29/2024. Disposed of by judgment dated 2/6/2025.
Obliged.
Yes, please.
Item number 17.
Yes, 17.
Filed an IA for condemnation of delay, 491 days.
ଆପଣ ଏଟା ଚାହୁଁଛନ୍ତି ଭେକେସନ ପୂର୍ବରୁ ଲିଷ୍ଟ କରିବା ପାଇଁ
Legal lordship follow करना
ସବୁଗୁଡାକ ଲିଷ୍ଟ କରିଦେବେ ସେ ଆଡଜଷ୍ଟ କରିଦେବେ ତାଙ୍କୁ ଛାଡି ଦିଅନ୍ତୁ କାହିଁକି ନା ବିକଜ ଆଇ ଏମ୍ ଷ୍ଟିଲ୍ ହିୟରିଂ ଆଇଟମ ନମ୍ବର ଆଇ ଥିଙ୍କ 8. So I have some assignments, so I cannot continue.
Not sure.
So ଆପଣ ଟିକେ ନୋଟ କରନ୍ତୁ ଯୋଉଟା ମେନସନ ଯୋଉଟା ବିୟଣ୍ଡ ଚାହୁଁଛନ୍ତି ଆଫ୍ଟର ଭେକେସନ ତାହେଲେ ସେଟା ଯାଉ नो अदर मैटर विल बी टेकन पॉसिबली टेकन अप
Lordship, the problem here is the execution case is pending. Until and unless this judgment is set aside, I am challenging the judgment. But
You have been hearing this court. Now this has become a speaking court regarding. So whether you obtain instruction, you deposit the money and get the order.
money is deposited. Already in the executing court, money has been deposited.
Okay. So that is why what is the evidence? Have you mentioned anywhere in the petition or a memo?
Lordship, I have given the court judgment of the orders of the executing court. Therein, 70,000 is there on that order itself. 70,000 is there, and as per my instruction, another 10,000 has been paid. The area is 1,90,000.
17 टा कोटे order कर दियो तो school दिन best करियो. कल किस करियो?
30.
30 से करियो. और केबे अच्छा?
I'll have to take instruction, but within the vacations.
Then just wait. Let us see. Let us see. It is sorry. ଆପଣ କୋ ଅନ୍ୟ କୁଆଡେ ଯିବାର ଅଛି?
Again, the nursing and the court, honorable justice.
ତାହେଲେ ତ ମତେ ତାହେଲେ ଆପଣ ଛାଡିବାକୁ ପଡିବ.
Again, it was short.
No, ଠିକ ଅଛି. But I remember your submission. ଆପଣଙ୍କ ନାଁଟା କଣ?
ଅବିନାଶ ଆଚାର୍ଯ୍ୟ ଅଛି। ଏ ଆଚାର୍ଯ୍ୟ।
ଆପଣ 70,000 ଯୋଉ ଡିପୋଜିଟ୍ ଅର୍ଡରଟା ଅଛି ପ୍ଲସ୍ 10,000 ଦେଇଛନ୍ତି।
ଆଜ୍ଞା।
ଠିକ ଅଛି। I remember.
My lord, item 18.
But page number 43 खाली।
I pray for a shorter date, my lord.
18?
Yes, my lord.
18 ने other state ଅଛନ୍ତି ଆପଣ?
Yes, my lord. Yes.
କେବେ ଆସିଲେ ଆମକୁ?
Next week.
ଆଜ୍ଞା ତ ସବୁ ମ୍ୟାଟର କରିବ।
My lord.
ଦେଖନ୍ତୁ ଅର୍ଡର କେବେ କରିବ?
11/5.
Okay.
Yes, any other matter, any Lord Council mentioning, Mr. Mishra?
22.
Yes.
That is also the continuation delay. The Lordship had issued notice.
Mr. Bhagavan Mahathir has appeared?
Yes. But
Along with
whom
Prabhu?
he has appeared.
So when Prabhu and Bhagavan appear, then what remains? Suvit Avasti. It take orders to do Anandu. Please. Kitu kare?
4/5.
We commencing 4/5.
Obliged.
What order is
Obliged.
Yes, Mr. Devata, item 23.
Yes, my lord. I'm for the appellant, my lord.
Mr. Devata, no, actually I am continuing item 8. So there are so many matters mentioned, so I am taking up after this. So 23 you suggested date. 23 you suggested date.
Okay, now.
Which date? After vacation or before vacation?
After vacation, my lord.
23 after vacation.
We commencing 6/7.
We commencing 6/7.
Obliged, my lord.
We posting कर देबे.
Okay.
Yes. Yes, sir. Yes, Mr. Prabhu.
This 23, in fact, we are supposed to take instruction before that. Yes.
No, but actually, I should not.
Manage.
May I continue?
71.3, yes. You are reading 71.3? Yes.
My lord. Roman 3. The prayer for amendment is to be allowed.
Yes, 71.3.
Roman 3. The prayer for amendment is to be allowed. 1.
70.3 no, sir.
Again.
71.
Sir, 70. 70.
SCC देखो please. There's some confusion. ଆପଣ କୋଉଟା ଦେଖୁଛନ୍ତି ଇଣ୍ଡିଆ କାନୁନ ଇଣ୍ଡିଆନ କାନୁନ
ନାଇଁ ମୁଁ ଅନଲାଇନ ରୁ ଡାଉନଲୋଡ କରୁଛି
ପବ୍ଲିଶର କି who has published online
इंडियन कानून
प्रॉब्लम हो ठीक अछि पढନ୍ତୁ.
One, the amendment is required for effective and proper adjudication of the controversy between the parties and to avoid multiplicity of proceeding, provided an amendment does not result in injustice to the other side. Then by the amendment, the parties seeking amendment does not seek to withdraw or any clear admission made by the party which confers a right on the other side, and the amendment does not raise a time-barred claim resulting in divesting of the other side of a valuable accrued right in certain situations. A prayer for amendment is generally required to be allowed unless by amendment a time-barred claim is sought to be introduced. In this, the fact that the claim would be time-barred because a relevant factor for consideration. The amendment changes the nature of the suit.
Changes
Changes the nature of the suit.
What change the language of Supreme Court?
Sorry, madam.
Yes.
The prayer for amendment is modified, or by the amendment, the other side loses a valid defense. In dealing with a prayer for amendment of pleadings, the court should avoid a hyper-technical approach and is ordinarily required to be liberal when the opposite party can be compensated by cost, where the amendment would enable the court to pinpointedly consider the dispute and would aid in rendering a more satisfactory decision. The prayer for amendment should be allowed. Where the amendment merely sought to introduce an additional or a new approach without introducing a time-barred cause of action, the amendment is liable to be allowed even after expiry of limitation. Amendment may be justifiably allowed where it is intended to rectify the absence of material particulars in the plant.
Not rectify, rectify.
Particulars in the plant. Absence of materials, particulars in the plant. The delay in applying for amendment alone is not a ground to disallow the prayer. Where the aspect of delay is arguable, the prayer for amendment could be allowed and the issue of limitation framed separately for decision. Where changes the nature of the suit or the cause of action so as to set up an entirely new case foreign to the case set up in the plant, the amendment must be disallowed. Where, however, the amendment sought is only with respect to the relief in the plant and is predicated on facts which are already pleaded in the plant, ordinarily the amendment is required to be allowed. Where the amendment is sought before commencement of trial, the court is required to live in its approach. The court is required to bear in mind the fact that opposite party would have a change to meet the case set up in amendment. As such, where the amendment does not result in irreparable prejudice to the opposite party or divest the opposite party of an advantage which it had secured as a result of an admission by the party seeking amendment, the amendment is required to be allowed. Equally, where the amendment is necessary for the court to effectively adjudicate on the main issue in controversy between the parties, the amendment should be allowed. In overall, last
so leave it there. So 71 is so which are the
70.
So which are the paragraphs? No, not 70, 71. Which are the paragraphs?
71
अरे आपण बुझी पाउनांती कि आपण गोटे भूल पिट धरचंती एसीसी ऑनलाइन एटा 71
आज्ञा मु
71 कर दे
आज्ञा
which paragraph you are relying on, which particular paragraph जो अपन पूछो
these are madam, these are the principal
most favor, which paragraph favors you
madam,
and which is against you.
Roman 3 per para I, Roman I, the prayer is to be allowed if the amendment is required for effective and proper adjudication of controversy. Here is the controversy between both the parties are adultery and cruelty. Madam, may kindly elaborate.
Don't elaborate upon that. The problem is that if you re-argue. This court is not considering the
My lord,
re-argument.
my lord,
So what was your case before the trial court is already there.
my lord.
So you are relying on 71.3.1.
My lord, totally কিন্তু ତା ଭିତରେ
Any other paragraph?
my lord, to avoid to the amendment para A, the amendment does not result in injustice to the other side because already pleadings is there and in my amendment petition also.
It's a serious thing. The pleadings are not there. Pleadings regarding Bengali Babu is not there.
That's why I want.
That is how I always tell you, just now telling that please, while reading a judgment, be sure that that is in your favor.
Madam.
And this judgment has been considered by this High Court for rejecting because LIC is a case where it very specifically says in these cases amendment should be allowed, and in these cases it should not be allowed.
Madam.
70 you are saying 70.3.2a amendment does not result in injustice to the other side.
Madam.
Yes. Any other paragraph you are reading?
Madam, just para B, by the amendment, the party seeking amendment does not seek to withdraw any clear admission made by the party which confers right on the other side.
That is not your case before the trial court. So that is not necessary. Or the case of the other side.
Para C, the amendment does not raise a time barred claim. This is not a time barred claim.
Leave it there. That is not the case. The court has rejected your amendment order 6 rule 17 application. What is the reason the court has
they said that this is the nature and character will be changed.
Correct.
But my lord, here my case is based on adultery and cruelty, and in my petition I define cruelty is on two types: mental cruelty along with physical cruelty. So in my petition I elaborately discuss regarding the mental and physical cruelty, my lord. The amendment which I
You are arguing for the husband or the wife?
For the husband, my lord.
So if then why you are arguing against yourself? If in the plaint you have not disclosed certain things, how can you now bring now?
My lord, the pleadings not completed, my lord.
Pleadings are completed after you have filed your evidence.
My lord.
So anyway,
my lord, just
So LIC, which other paragraph? 17th paragraph, which other paragraphs?
Para Roman 2, my lord. The prayer for amendment is generally required to be allowed unless proviso part. Para Roman 2. Para Roman 3.
No, just read it because your paragraphs are not matching.
The prayer for the amendment changed the nature of the suit. By the amendment, a time but a prayer for amendment is generally required to be allowed unless.
Yes.
तापरे पारा जो रोमन
unless टा आपण पढौतुनी unless is against you.
माने से कहले कि जदि ए सब क्राइटेरिया
unless whatever is unless that has been relied by the trial court to reject your claim. You must understand that unless is not in your favor.
Para V triple I amendment may be justifiably allowed where it is intended to rectify the absence of material particulars in the plant.
How it is in your favor?
My lord, here is the material particulars which is not in my plant. I want to incorporate.
You have added the not. Please read it.
My lord.
That is against you.
माने जदि
आपण पढु ना, that's the problem. आपण मिस करछंती.
A prayer for amendment is generally required to be allowed unless जदि ए सब थिबो ता
नहीं ओडिया रे कोन दिसटा पढंतु कि हिंदी रे सेंटी करंतु. Don't do injustice to a Supreme Court judgment. Anyway, 71.8 you are relying on. Then what next? What else you are? That is any other paragraph, or you are through with LIC?
Not other judgment also.
No. LIC रे आपको paragraph रहिला ना सरला.
Para IX, sorry, it proviso part.
पढ़ो. Para IX.
Unless part a prayer for amendment is generally required to be allowed unless. A, B, and C. And Roman 1. the prayer for amendment is to be allowed. 1A, B and C.
ठीक है जोटा आपण ऑलरेडी प्लेस करी सारले
Again.
करेक्ट
And 2 also, to avoid multiplicity of proceedings provided.
सेटा केमती मल्टीप्लिसिटी कोचनी आपण जो प्ली नेचंती आपण you have already taken the plea of cruelty. In amendment also you are saying the same thing.
My lord, this is a elaborate discussion.
The answer cannot be, every answer cannot be, my lord. You have to answer to the court's query.
My lord.
When you are taking a plea of adultery and cruelty in the plaint itself, then again another you are filing amendment stating the same thing. You must
This is
understand
not
that.
the same thing, which I want to incorporate all the
Different
pleadings.
facts, that's the problem. Different facts.
This is these
Hope
facts.
you understand what I am saying. Is it your case that you have not taken the plea of adultery and cruelty? You have taken the
This is my
so
case.
that is what being asked to you. If you want
But
to
in
say
an elaborate manner, this
please
is not
appreciate,
discussed
please
in
appreciate like this.
in elaborate manner. This is not discussed.
elaborate. Not elaborate. You are arguing against yourself. What are the grounds of seeking divorce?
In section 13 of the Hindu Marriage Act. Adultery, cruelty, desertion, and
Stop there. So now you have said you have understood it. At least to remember. Suppose you have taken adultery and cruelty, not taken desertion. And desertion by amendment, then that is what you are reading.
Madam.
So don't read what is against you. You have already stated adultery and cruelty. By amendment, you are not seeking introducing desertion.
But in
It
my
can be also say unsoundness of mind. So what is already there? It cannot
but
be disturbed.
Bengali Babu things and the physical cruelty and the
is
mental
that
cruelty, all these are not.
You have already there. You have pleaded that. You have pleaded
That
and
is
stated
not
the facts.
elaborate discussion, my lord.
Whatever elaboration you can read the plate, that is the law you are reading just now.
My lord, till
You are not
that
reading the judgment you are citing LIC. LIC is precisely saying that. Read it again. The paragraph.
another judgment also in my favor, my
Regarding Order 6, Rule 17, cite one decision. Don't cite because LIC is an authority.
this court previously also have asked me regarding that whenever the evidence examination in chief is filed, then how amendment is to be allowed.
Commencement of suit, that's another point. Upon Order 6, Rule 17, I will cite for you. What other judgment on Order 6, Rule 17? LIC is actually one of the best.
This is also referred in 2024. Another matrimonial disputes.
Don't multiply Order 6, Rule 17. Order 6, Rule 17, apart from LIC, which other judgment you are citing? If you have any, or LIC is sufficient.
No, Nitaben Dinesh Patel in
Order 6, Rule 17.
2021. Again.
Citation code.
Nitaben Dinesh Patel versus Dinesh Dhyana Bhai Patel.
Citation code.
Civil appeal number 5.
So, boy, citation code civil appeal kucho. With Order 6, Rule 17.
Again.
Any other judgment? Beyond
6 Rule 17 and
beyond LIC is one of the actually the best. LIC is the side corruption.
na ethire bhi discussion hechi by Honorable Supreme Court.
But they have reiterated the LIC principles.
Para 7, para 6, para 7.
Yes.
May I please, ma'am?
No, not necessary. Because
Para
you are wasting
6
time actually. By reading LIC principles again, what is the point?
LIC principle ka nahi hai isme. ଟିକେ difference
ଆଉ ଅଧିକା କିଛି ନାହିଁ ତାର
ଟିକେ difference ଅଛି ତା ଭିତରେ
LIC ରୁ ଅଧିକା କୋଉଥିରେ ନାହିଁ
The order 6 rule 17 provides the amendment of the pleadings. When trial has commenced, after that the amendment is allowed by the Honorable Supreme Court. In para 7, para 6 and para 7.
it's relying on the provision because any stage
At any
it can be allowed provided that is the problem for you provided it does not cause change nature and character of the suit. You alleged cruelty adultery by Kranti Sahoo. Now you are alleging adultery by Bengali Babu.
Both.
That is the problem.
Both. I am not changed. I am not shifting my.
So now after the hearing is complete, at the stage of argument, you discover the adultery with X. Now you discover with Y. And the other problem, Madam Sharma, what you have alleged, those events are not subsequent to filing of the pleading. That is the other problem.
Just
so
allow me.
You know, Madam Sharma, your client knows adulterous relationship with Kranti Sahoo.
Previously, that was with the doctor. After that, Kranti Sahoo.
This is not a debate competition. You must allow the court to complete the sentence.
Sorry.
He knows Kranti Sahoo. He is no Bengali Babu, and nobody knows how many. Even you remember the adulterous relationship of your wife with somebody. You come to court and file an amendment. That the court cannot do. The reason being, there is no concept of graver form of adultery if somebody is in adulterous relationship with 1, 2, or 4 persons. One way of looking at it. Now, suppose if you want to prove Kranti Sahoo, that is enough for deciding your list. If you are able to prove your relationship of your wife with Kranti Sahoo, that is enough. You must understand that. Now, after filing your evidence, cross-examination in chief, you remember, okay, now I remember she has a relationship with Bengali Babu.
After that, not prior to that.
No,
but whenever this
prior to what?
Prior to this fact.
Which date is being told to you?
On 24.
Don't say everything. After you filed your plaint alleging relationship with Kranti Sahoo, now you allege relationship with Bengali Babu.
When the document is come within my knowledge, then I came to know that this document.
That document is a before the Sahoo Samaj.
But that is not within my custody. That is within the custody of elsewhere.
The problem is that the document authored by you.
But that is not within my custody, my lord.
Not custody, knowledge. Knowledge
also.
Diligence is not custody.
Whenever the opposite party
Order 6 Rule 17 read. It says about due diligence, not about custody.
My lord.
So don't do that. Don't spoil the case. You have already done enough damage. You see, the lawyers actually do damage to the case. This is a classic case. It's a classic case where by filing affidavit, you say, I know. Because the entire narrative is prior to filing of the suit. And you are saying that I made a complaint to Sahoo Samaj. That complaint is not within my custody, so now I seek amendment. Can that be a ground? That cannot be a ground.
My lord, just allow me to.
No, you complete first of all. Instead of continuing your speech, you complete the decisions. Nita, then Order 6 Rule 17.
I know.
On the point that the suit has not commenced.
While the para 6 and para 7.
Para 6 and 7 I have noted. Or if you want to give that paper citation, you give it. It's up to you.
Therefore, in some facts, I have come to the knowledge subsequently.
Leave it. You have read 6 and 7. Don't get stuck with
another. From civil special leave petition.
Order 6 Rule 17 or anything else?
Order 6
Rule. Order 6 Rule 17 the LIC is the authority. No better judgment than LIC you can rely upon. Don't multiply.
Discussion
don't multiply the ଆପଣଙ୍କର concept of law is actually different. ଆପଣ ଯୋଉ concept ରେ argue କରୁଛନ୍ତି that is not beyond my comprehension also. By multiplying authority you cannot change the law. Actually, no case is decided on facts. Read ratio decidendi. Ratio decidendi of a case is that which applies to all cases irrespective of the facts. So don't multiply the citations. You give the best citation you are relying on. If you are not relying on LIC, leave it. But now you have read LIC elaborate. Then you have cited Nitaben, which reiterates. So you give those judgments, order 6 rule 70.
And Dinesh Goyal, alias Papu.
So can you hand them over or you have copies?
After getting one Xerox copy, I handed over.
You should have the decency of presenting a case before the court with a copy when you do not have the citation. I've been asking you give the citation, you are not giving also.
Sorry, my lord.
Why should you be sorry after committing something? You come to court unprepared. Do not bring the citation. Do not give the reference. This is not done, madam. We are being watched. A lawyer is citing a case without giving a copy, not going the citation. I thought that you are unable to locate the citation actually. It is not there. Next case study on. Set up chade. Nitaben dot proceed. Upon what kind of jumping up. Next citation टा कौन थिला?
Nitaben Dinesh Patel. Approved.
Dinesh Goyal.
Dinesh Patel.
Dinesh Goyal को paragraph. You money भी रखना. You have to remember things better. Dinesh Goyal सेटा देखो. तो first page टा देखो. Citation कौन? Party ना कौन?
Dinesh Goyal
versus
Suman Agrawal, Bindal and others.
So other cases?
These three citations.
Nitaben versus Dinesh. आपण Dinesh Goyal और
Dinesh Goyal alias Papu versus Suman Agrawal, Bindal and others.
आरोटा कौन?
Avarota
Nitaben versus Dinesh, not Dinesh versus.
Dinesh Patel versus Dinesh Dhanya Bhai Patel.
Citation कौन है?
Civil
appeal का case number. Citation होची INSC 2024 Supreme Court 726.
नहीं एटा रिपोर्ट टेबल पर
ऊपर बापटे देखंतु ऊपर बापटे टॉप रे कोन लिखा है
एटी मेंशन ही नहीं
बापटे देखले डाण पटे देखछन बापटे टॉप रे देखंतु
नहीं है सर
अरे आपण कोन को फिर भूल भाल करले दिनेश पड़े अपन नीताबेन धरले दिनेश देबे साइड कले
दिनेश गोयल पप्पू
तार साइटेशन केते कोन
स्पेशली पिटिशन
केस नंबर से
2
यस से पूछले बर्तन पूछले
2024
ठीक है so now at least today I was sure that there is a citation of Supreme Court also yes
मरदा
आपण जेते बेले citation पचराबो don't tell the case name कहिबे जे मु citation जानिनी civil appeal number एते जदि कहिबे that's not the citation आपण दिनेश गोयल और दिनेश पटेल को नीताबेन को नहीं कंता भीतर yes दिनेश गोयल रो को पैराग्राफ
दिनेश गोयल रो पैराग्राफ 11 11:1 11:2 11:2 का Roman 1, 2, 3 and most importantly IV Roman IV
ठीक है तो ऑर्डर 6 रूल 17 एती कि तापर नेक्स्ट
इधर कोइला some general principle to be kept
it is not we have already spent 45 minutes on order 6 rule 17 and more you read order 6 rule 17 you will not find anything beyond LIC by
just allow me to the concept which is this honorable court taken regarding that both the pleadings in my
Point question. Don't give an introduction. Don't allow me to do this. No, you straight away come to the point. What is the point you are arguing?
my lord, in OP number 1 during his cross examination para 30 just
cross examination shoot re arambo heyni aage
na eta allow heyni mane seta maintenance case re mane
ठीक करंतु नहीं. You come to the point.
when this
Your point is that if in the 125 case something has been stated which requires amendment.
no, in my MAT case
case में बिल्कुल cross examination आरंभ
है नहीं.
So I cannot. The evidence is inadmissible. Have you read Evidence Act?
Again.
What are the 3 criteria?
18 rule 4 evidence is laid down whenever.
Admissibility. First is what?
Admission, then
relevancy, admissibility, weight. Whatever has happened in some other case that cannot be admissible in a evidence in your MAT case. If you want to cite that evidence, it's not admissible because it has to be rendered as part of the evidence on in chief or in cross in the particular examination.
But when both the parties pleaded in different,
if there is per chance there is analogous hearing, cause of action is same. Suppose how it can be like a cross appeal, cross suit. In the written statement, you file a cross objection. Then there is a possibility, but not in a 125 CRPC proceeding. What is the main difference between 125 and MATA?
MATA case is for section 9.
Right. What is the difference in trial? 125. Have you read 125?
125 is in summary in nature.
125 is summary in nature. You are telling that. So that is not admissible. So don't damage your case. Guys, I mean, you are taking a plea that since 125 CRPC proceeding, then something has been stated. That should be done. So that is not the way you are conducting cases.
But whenever there is nothing in in pleadings, everything.
Don't imagine. If you have anything, check the case law, check the provision. Whether in CPC regarding evidence or written statement, any provision is there. First thing, answer is no. Second, if the case law has evolved, answer is no. Third thing, the nature of proceeding is different. 125 can be awarded to a mother, father, illegitimate child, any kind of relationship, divorced wife. Suppose divorced wife gets maintenance. Why? Because that is a MAT case is already disposed of. So please appreciate that. So you are saying that regarding completion of the before that other point in Order 6 Rule 17. If you have any citation or you close it.
My lord, may kindly fix another date, please.
No.
My lord, just
today I have already again spent another 50 minutes. This is not the way to interlocutory application. I will one day 1 hour 10 minutes and another day 50 minutes. Then again installment another. You argue your point. You say that I have some decisions to show that even after filing of the examination in chief, the suit has not proceeded. That will, if you have any, then and never waste your time in multiplicity of this citation. To always cite the best one.
My lord, whenever the evidence is not in, started, because only
point. Don't give a speech. It is not a straight away come to the case law. Which case you are relying on?
That's why I'm seeking some time, my lord. My mother health is not good. That's why I'm totally unable to.
You have to do well in your profession to fend for your mother also. The way you are proceeding, you are wasting the time of your mother also. Please appreciate that. Whenever you are not giving time to your case, hand it over to your colleague. They will do it free for you.
I don't have any colleagues, my lord.
Colleague at the bar. How much time was spent with the senior in chamber?
I'm not.
So for doing practice
attached with any of the seniors, that's why.
For doing practice in trial side, my humble experience is that I never ventured because I never had occasion to go to a senior. Though I went, purposefully I went to trials to watch trials. By suppose say Mr. Behra is, I know Mr. Behra senior suppose, or Mr. Pradhan senior. I go along with them. I simply went to see trial, but I never ventured. Though I intended बंद कर दे
Pardon me, kindly
Height of
take,
wastage of time. Height of wastage of I could not go beyond it. I cannot.
beyond pleadings, the facts, this is,
Problem is that-
trial court is a fact finding court, madam.
You are unable to, because that is how your perception, you are doing that, you are thinking that these are the valid grounds to be argued. Because as you said candidly, audio. $12.50 to $110. Audio ତାଙ୍କୁ କହିଦେବେ ଯେ ଆପଣ ତାଙ୍କୁ କହିଲେ ସେ ବୁଝିପାରୁନାହାନ୍ତି କେତେ କ'ଣ କରିବେ ଆକ୍ଚୁଆଲି ଆପଣ ତାଙ୍କ ମୁଣ୍ଡ ବି ଖରାପ କରିବେ ସେ କିଛି ଦିନ ପରେ ଅର୍ଡର 6 rule 17 ଅଦର ୱାନ୍ ହୋଇଥିଲେ ସେ ବି ଏଗୁଡ଼ା କରିବେ the matter was continued to be heard from 310 କେତେ ବାର ମାନେ 3:20 3:10 3:10 PM up to 4 PM. When the counsel for the petitioner seeks further adjournment after placing the decision on order 6 rule 17, LIC, Nitabe, Dinesh Goyal. Right. What did it? It was a 5-year order. Bye. She submits her personal difficulty due to some ailment in her family. In considered view of this court, the matter is sufficiently heard. 1 hour 10 minutes on the last occasion. And again for 1 hour 10 minutes today. The learned counsel for the petitioner refers to certain facts. Those are supposed to be grounds for seeking amendment. In considered view of this court cannot advert to the facts apart from those are in the pleadings contained in the application order 6 rule 17 as well as the objection there. Yes. What else you are saying? Facts I cannot take up.
Madam, or page 42 in their objection, para 8, 5th line. During the cross examination,
That is there. You don't have to.
in his cross examination, he stated that this fact is.
Again, the learned counsel for the petitioner, almost 10 occasions, has referred to the cross examination. That is part of
Objection raised by the opposite party, madam.
the cross examination and
Not
and the objection raised by the husband.
raised by the wife
Raised by the wife.
in 617 petition. Raised by the objection.
ଆପଣ ଫେର କାଇଁ ମନେ କରୁଛନ୍ତି ତାହେଲେ
ନାଇଁ ସେଥିରେ ସେମାନେ ଦେଇଛନ୍ତି ଯୋଉଟା
କ୍ରସ୍ ଏକ୍ସାମିନେସନ କଣ କହୁଛନ୍ତି
ନାଇଁ ସେଟା କ୍ରସ୍ ଏକ୍ସାମିନ ନାଇଁ ତା ଭିତରେ ଅଛି para 8 ମାଲଟ
ସେଇଟା ଛାଡି ଦିଅନ୍ତୁ ସେଇଟା ଆପଣଙ୍କର ଯାହା ପ୍ରିଡିକ୍ସରେ ଅଛି ଇଟ୍ ଇଜ देयर you don't have to go through whatever has been authorized before the trial court before the trial court ଆପଣଙ୍କର order 6 rule 17 application or ତାଙ୍କ objection
ତାଙ୍କ objection କଥା ହିଁ ମୁଁ କହୁଛି
so leave it there you don't have to re-argue that I cannot take up a re-argument of this matter. The learned counsel for the petitioner again and again on several occasions refers to a proceeding under section 125 of CRPC into bracket since repealed and substituted by perimetric provision of section 144 of DNSS 23 bracket closed. He submitted that due to certain statements in the state proceeding, the petitioners, the order 6 rule 17 application should be allowed. In considered opinion of this court, a parallel proceeding cannot have any bearing on the proceeding under the civil proceeding under section 13 of the Hindu Marriage Act. Yes, sir. What other point?
Madam, may kindly fix another date.
The Lord also for the petitioner. Six further time. In considered opinion of this court, the petitioner has been allowed, the Lord Counsel has been allowed sufficient time to argue her application, to argue the writ petition on several days. She has been shown sufficient indulgence in citing the giving the decisions relied upon. No further adjournment cannot be granted. Matter is reserved for judgment. Hearing of it, matter is reserved for judgment. What is the next case? Connected ta kon?
So to be under section 9, which is against the order passed by the Honorable Family Court 10928.
Yes. What is the prayer there?
The amendment is disallowed by the Honorable Family Court. Seeking amendment in my written statement.
Amendment of written statement has been rejected.
Written statement. Section 9 of Hindu Marriage Act.
So anything else other than whatever you have argued?
No, my lord, this Honorable Court not given any further
So this matter you want to argue today, because you are arguing basically nothing.
My lord, then this matter is fixed another date.
No, you complete your pleadings today. What you want to argue in this matter?
Something. This matter may kindly fix another date, and this is for reserved for judgment.
So order 9, section 9 written statement. What is your argument? You place the order. You
Please prepare he, sir.
Then thank you. Apna kahile nita pratham 2 घंटा पुढे पोहोचन. When do you want this matter?
Which date?
Yes.
After vacation, madam.
No, not after vacation. Tomorrow.
My lord, tomorrow I am not here
No,
because
this is not a. I mean, your place for manipulation.
no, my lord, there is nothing in intention to.
Because the other matter you should have argued last time.
My lord.
You gave an impression that since you are arguing this matter, you will not second matter. Because you said that these are the same points. Same amendment order 6 to 70.
But it's taking some time.
And you are seeking amendment of your pleading again, written statement.
Madam, may kindly fix another date for this.
But you want the court to wait for after vacation. This
No, madam, prior to vacation, but
Yes.
madam, may kindly fixed on after 20th.
We commencing 20th. आज कितनी तारीख है?
जी,
21 तारीख. 20th माने of April.
नहीं, May.
No.
May first week तो meeting नहीं, May first.
April allow करिवे ना करिवे.
मम्मी को नहीं कि जो अभी तो हेल्थ कंडीशन
आपण काहे की तले केस टेकअप काहे करू छथि when the then it has to be mentioned in the court after arguing for 2 days 1 hour 10 minutes each day. The allotted counsel for the petitioner seeks further adjournment on ground of ill health of her mother. Such conduct is not appreciated. That after lengthy argument, the petitioner is after consuming sufficient time, the petitioner is seeking time. The matter shall be taken up. It shall be listed on TC chair for fresh admission. ତା ପୂର୍ବ ପାଠରେ ଯୋଉଟା ଲେଖିଲେନି ତା ସେଇଠି ଲେଖନ୍ତୁ since the other matter is adjourned to TC 4/2026, this matter shall also be listed on the said date. Both the matters shall be listed under the heading to be mentioned. That is.